We got like
Okay.
3 minutes. Yeah.
Okay.
Somebody just joined. Or no, was that me starting the broadcast? Maybe that was me starting the broadcast. Let me start the recording. All right, so good morning. We're going to officially start. For those of you who may not have been with us before or might not be familiar with me, my name is Trisha Teague. I am the CEO of the TREP School, where we teach on entrepreneurship, and we have been doing sessions through our contract with the Illinois Department of Commerce and Economic Opportunity for training and technical assistance for those who plan to apply for a cannabis license, either just applied 2 days ago for their craft grow, infuser, or transportation license, or may have applied in January for their dispensary license, or may plan to apply with the next round in 2021. So this is a session that's open to anybody, but our focus is especially on social equity applicants. And so today's session is part of a series. This is part 1 on HR and employment practices. So Desiree Henderson is our presenter for this entire series, because she is a person whose specialty and whose business is all about HR. Like I said earlier, all of these sessions will be recorded. So if you have any, notes or different things and you're like, oh, I missed something, don't worry about that. You'll have access to the recording after it's done. If you want to sign up for future sessions, because some of you signed up for just one and some of you signed up for all 6. So if you want to sign up for future sessions, they're all available on our website. You can go to cannabistrainingil.com. and then you'll see the links to each of the individual sessions. Our next one is in, I think, 2 weeks, Desiree, is that right? May 22nd?
Yes, that's correct.
Okay. And so that's where you'll find all that information. We will have some more stuff coming up around security later in the month. And I am still available for one-on-ones. I also wanted to make sure that everybody knows that if you feel like you might want help in this area, that we also will have time available for one-on-ones with Desiree. So you can request that as well, in the same way that some of you have already done this, requested one-on-ones with me. You can do the same thing, and then we'll work out a system for making sure that you get that time with Desiree. So on that note, I think I will hand it over to Desiree. Like I said, she is the CEO of For Hire HR Solutions. She could tell you more about her business, which I think there's a slide for that. And I am going to bow out. I will still be here, but I will turn my mic off and I will turn my camera off and give Desiree the floor.
Thank you, Trisha. I'm excited to be here this morning. Good morning, everyone. Thank you for joining us. Just a brief background about myself. I am a seasoned HR professional. I say seasoned, but there's always more to learn, right? Every time I think I've come across about every incident in HR, something else crazy finds its way to the forefront. But I've been doing this for about 20 years now. I also am adjunct faculty at a couple universities here in Southern California, where I'm from. I've worked for a lot of major companies like Paychex, McDonald's. I've worked at General Motors. I've also worked at smaller companies. I've worked for nonprofits. I've worked for Indian tribes as well. So I have a good variety of work environments. I've also worked with a lot of startups also, and currently have clients that are in the startup phase and just started their businesses last year, and working to grow them and help them maintain their compliance. I've also do stuff here locally with the SCORE workshop committee. SCORE is a part of the SBA that helps businesses get up and running as well. So I do some work with them in workshops, and that's a brief kind of overview about my background. Before we get into our presentation today, just a quick disclaimer here. A quick disclaimer, I am an HR professional and not an attorney, so I just want to say that up front. The seminar will go through information that I have learned over my years recently and best practices. It is not intended to be any type of legal advice or give you any type of legal representation. Okay, so with that said, we'll get right into it. Our agenda today, we are going to focus on kind of the foundation of HR and compliance in employment and labor laws. Those start with those federal and state agencies. So we'll go through those agencies, the laws of the agencies, the importance. We'll talk about compliance. We'll go through some tips for new business. And then at the end, we'll have questions as well as questions throughout as we go through our different sections this morning. So one of the first things I'm going to want to go through is just talking about some of the HR basics. When we take a look at our laws, they start at the federal level. They start about with different executive orders and different bills and things going through Congress. And once those get approved, then those get divulged down to the different federal or state agencies that are going to be overseeing and enforcing those laws. When we talk about HR laws, primarily the laws are going to be based off of either it'll affect everyone, it may be based on the size of the company, and we'll kind of talk through that today. And then some may be industry specific. Okay, we're going to start with the different departments to know. There'll be a lot of questions, a lot of information that we'll go through this morning. And like we said, there'll be kind of some spots at the end of each kind of the subsections to allow time for those. The first department that I want to start with will be the Department of Labor. The Department of Labor handles our wage and hour laws, federal, retaliation, workers' compensation, and safety. Next, we have the Equal Employment Opportunity Commission, also known as the EEOC. As with HR, as many other industries, it's all these acronyms. So we'll discuss that today when I say the DOL or EEOC or DHS or something like that. The EEOC, though, they oversee and enforce laws in regards to disability, harassment, and discrimination. And then we'll take it locally. We'll talk about your Illinois Department of Human Rights. They're your local EEOC, and they enforce sexual harassment and discrimination and laws in regards to that. We'll also go through the Illinois Department of Employment Security, and then talk about Department of Homeland Security. So the Department of Labor has several different divisions within it. They have 27 total, and we're going to focus on kind of the top few today that you're going to most likely have some type of experience with. So who is the Department of Labor? Their goal is pretty much anything related with any type of employees and promotion and employment. They foster, promote, and develop the welfare of wage earners, job seekers, and retirees. Their laws oversee any type dealing with employment, work-related benefits, retirement benefits, anything and anything that touches the workplace and employment in the work environment. Under the Department of Labor, they have 27 agencies that enforce major laws. The Fair Labor Standards Act, the Occupational Safety and Health Act, Worker Adjustment and Retraining Notification Act, the Federal Contract Compliance Programs. They have Employment Retirement Income Security Act, Workers' Compensation, and they're also the department that has the laws that says that you have to have labor posters in your work environment. We're not going to go through all these in detail this morning. We're going to focus on the top ones that you definitely want to make sure you have on your radar and you're familiar with. We're going to go through the Wage and Hour Division of the Department of Labor. We'll talk about OSHA. And some of the other departments they have under them are going to be, the Bureau of Labor Statistics, some of those just to name a few. The Fair Labor Standards Act. The Fair Labor Standards Act is our federal law that oversees our wage and hour laws for all of the United States. When we would take a look at coverage and see who falls under that, we separate that into what's called the enterprise coverage, and also we have our individual coverage. When we look at what enterprises or companies fall under the FLSA, we're taking a look at how much and the amount of businesses that they do. So these are enterprises or companies that have at least 2 employees. They have an annual dollar volume sales of $500,000 a year, or they're hospitals or businesses that provide medical or nursing care for residents, schools and preschools, and government agencies. So that's one of the part when we take a look at, are you an entity that's covered under that or will be covered under? If it doesn't look at the enterprise coverage, the next thing we take a look at is the individual coverage. So even when there's no enterprise coverage, employees are protected by the Fair Labor Standards Act if their work regularly involves them in commerce between states. It also covers workers who are engaged in commerce or in the production of goods for commerce. So just to kind of make this a little bit easier to understand outside of all the fancy terms, is that whether a company is covered under the enterprise coverage or individual coverage, about 99% of employers fall under the Fair Labor Standards Act, whether it's the amount of business a company does or the employees. And just to kind of break it down, when some people think, oh, you know, I'm not involved in interstate commerce. If you have a product that you sell, for example, that comes from another state or you're going to send to another state, you're covered. If you have a service, let's say a call center, the call center may take calls from another state, you're covered. So they make it very, you know, they cast the net very wide to just show that, you know, whether you're doing this, that, and the other, most likely you're a company that falls under that. And it's important to kind of determine, when we determine who laws, who they attach to in regards to coverage, to know how your company is covered and what compliance means in that realm. Okay. So some of the things that the Fair Labor Standards Act does is establish the federal minimum wage. Right now, federal minimum wage is $7.25, and in your state it is $9.25. And, you know, I point that out to say that there's going to be some differences in between what federal laws do and what state laws do. And we'll talk through that more as we go throughout today's presentation. And that's okay when we have a different state law that's different than the federal. What they take a look at is if there's a law that a state puts in place that's more beneficial to the employee, then it's fine. What couldn't happen would be the opposite way, right? You couldn't have the federal at $7.25 and you know, Illinois at $7. That would not be okay. That would not be allowed. It also establishes federal overtime rules. They define the hours worked under the federal laws, and hours worked is important because that's the hours that we want to define to know when we need to compensate someone. It also addresses worker misclassification. When we talk about misclassification, we're talking about exempt employees or non-exempt, and that's pretty much taking a look at hourly versus a salaried, which is what's more commonly referred to. We have record-keeping requirements, and it also covers our child labor laws federally. The FLSA enforcement, so with these laws, they have the enforcement of them, and so we take a look at the enforcements can go back 2 years. Limitation generally applies to back pay and recovery. Sometimes if they think that something is willful or someone's a repeat violation, they will go back further. What'll usually happen is if they found that a company is out of compliance, they'll do some type of, you know, voluntary agreement where instead of bringing suit, they'll say, okay, you admit that you were in violation of this. These are the wages. These are the damage that come with that. And then this is what you owe. The company agrees and they proceed accordingly. And there's no further things that are provided. Another thing is that an employee does not have to necessarily go to the Department of Labor or corresponding agency. They can always get an attorney and file private lawsuits as well. Companies that are not successful with that not only end up potentially paying back pay or liquidated damages, they can have attorney fees, court fees, and a whole slew of other fees that are involved in that. Willful violations, anytime that a company is a repeat offender, or they can see that the company was going out of its way to hide their non-compliance, those are considered willful. And what'll happen with that is that the civil penalties, when it talks about for each violation, when we take a look at, and we'll see in different laws that we talk about today, they'll talk about each violation. Each means every day, every employee that violation happens has a dollar amount attached to that. So when you think about that, if you're a company that even has 20 employees every day, let's say you're not paying overtime correctly because they're misclassified, every day, every time, every employee that works is a dollar amount that's just cha-ching, adding to that potential liability. So that's why it's very important that we make sure we get it right from the beginning. That way we don't have any of that exposure. The Wage and Hour Division of the Fair Labor, of the Department of Labor that enforces the Fair Labor Standards Act, are carried about through investigators stationed throughout the United States. So even though a lot of these departments are stationed or headed back in Washington, they have local offices. Even agencies that have their own state offices, they still have a division of Wage and Hour here. What will happen is that these investigators will gather data. The data on wages and hours and things like that are going to be all from the record keeping that companies are required to maintain. That's going to be copies of your payroll records, timesheets, your employee files, and things like that. They're going to want to take a look at. Willful violations also may have not only just have fines that go with those and pretty extensive fines, but again, if they find that the company is purposely trying to mislead the government and falsify things, it can also mean imprisonment and jail time as well. And then we talked about the slide before about willful or repeated violations. When we talk about each of those violations, when I mentioned each day, that's $1,000 that they account to that. Ultimately, if they find that a company is very much out of compliance, they're willful. Anytime a company kind of cuts corners, right? It's a form of cheating. And so when they take a look at that, it's not fair. It's not fair business practice when other companies are, paying the right amounts and doing things legally. It puts them at an unfair business advantage when you have a company that's cheating. So what they'll do to kind of even it out is they'll say, you know what? Anything that you guys have benefited from being out of compliance, whether it be not paying the right minimum wage or overtime or inappropriate child labor, they will prohibit or stop the shipment of goods or services that's connected to any of that. So essentially they have the power to really kind of shut a business down based upon that. So we definitely do not want that. So that's why it's really great that you guys are getting this information early on in your businesses and understanding these. So just to talk about a little bit about enforcement, right? Because anytime I do these seminars, I hear companies say, well, oh my goodness, why would people, risk this, and a lot of times that, companies think, oh, I'm small, they're not worried about me or what have you. But each year, as you can see here, the Wage and Hour Division of the Department of Labor, they've increased in their enforcement because they want to get those funds back to those workers, because anytime that the company is not paying, it's shorting the employees. So last year, it was a record-setting year, and they were able to retrieve $322 million in back wages that were owed to workers for 2019. So that's a pretty big deal. And you see each year that they're doing enforcement, it increases and increases. So we kind of give an overview of the laws that Fair Labor Standards Act does cover. Here's a little bit about what they do not cover. They do not mandate vacation, holiday, severance, or sick pay. So that's still discretionary and up to a company whether they do it. They do not mandate meal or rest periods, holidays, vacations, premium pay. So if you want employees to work on the holidays, work on Sundays, they don't cover any of that. They don't require it. Discharge notice, they don't say that you have to, inform someone their reason for discharge. When it talks about minors in the workplace and how old they have to be, limiting those hours, they don't do that. Pay raises, fringe benefits, they don't cover any of that or mandate it. Now, I say that doesn't fall under Fair Labor Standards Act. Again, that's our federal law. There may be some local laws that attach to that. Or if you do decide to offer vacation or meal and rest periods, at that point, there may be some caveats attached to those once you do decide to offer some of those. What this is saying is that they don't mandate or require that a company offers any of these. Okay. The next department that we're going to move on to is OSHA. And our Occupational Safety and Health Act, or OSH, more commonly known as OSHA for the department that administers it. The Osh Act of 1970 applies to each employer who is required to furnish to each of their employees employment or place of employment free from hazards. So essentially saying that you must provide a safe work environment free from hazards. Those hazards could be, obvious hazards in regards to, working in a building that's not under construction, or that's going to be, safe and just the work environment and physical harm. But it also talks about also complying with that. It could also be providing safety and things like that in regards to work environment. And federally, safety and health laws are enforced by the Osha, which is the Administration Occupational Safety and Health. Also, again, similar to, we have our federal guidance, some states also have decided to put their own safety laws and enforcement. So just a brief overview of some of the top 10 most cited standards of requirement. So OSHA is pretty much kind of vague in their application. Of course, they have all the breakdown per industries and they get more specific there. But overall, they're saying, make sure that you have proper signage in the workplace. Make sure that you are properly notifying any employees of any potential hazards, training them on that, having the postage, having the, we talked about training, removing any obstacles, no loose wires, things like that in the workplace. So when they take a look at the most top cited safety standards that they usually come across federally are going to be issues with fall protection. And we have the fun thing here that they had on their website here, hazard communication in regards to hazardous materials in the workplace. If you have things that are deemed to be hazardous, even simple cleaning materials that you have, and any type of chemicals, there has to be a material safety data sheets provided to employees that says, hey, this is what we have in the workplace. If you come in contact with this is how you're going to handle it. If by chance you have a spill with this, it splashes in your eye or something like that, it also goes through how you fix those situations. There are companies that have violations of that. So when it refers to that, that's what it means. Scaffolding and construction, respiratory protection, those are industries, in construction and, painting and things like that are required to have certain types of respiratory protection for employees. Lockout, tagout, those are industries that have certain machinery that has a what's called lockout, tagout, automatic lock to help them, that machine from just going off and injuring someone. Ladders, of course, and climbing in the workplace, powered vehicles like forklifts, fall protection, machinery and guarding, and eye and face protection. So again, these are often the most cited violations because those are still the areas and in certain industries where they still see that the most injuries are happening. When we talk about enforcement and fines that if they come into your worksite that they can have, other serious than non-posting requirements can be, almost $14,000, again, per violation. Failure to abate or fix the issue could be another almost $14,000 day beyond the abatement date or that you were told to fix it. If it's willful or repeated, you see again, they do not like the willful or repeated. They, then the dollars add up immensely, so it goes up very quickly. And, other things that could be simple things of violation in the workplace. I remember when I first started doing safety for a company, I did a walkthrough with our insurance company. At that time, I was an HR associate for a retail chain, and we sold appliances and things like that. And just, simply taking a look through and having wall outlets that didn't have a cover over them. At that time, and this was well over 10 years ago, each of those was a $250 violation that the local authorities had for that. I mean, just simple things, exposed wirings were different violations. And so if there's an OSHA audit and they come through and they knock on your door, which they can do, they don't have to schedule themselves ahead of time necessarily. They can pop up and say, hey, we want to run from OSHA. I'd like to do a walkthrough and a brief audit. Do you have some time for that today? Now, you don't have to let them in unless they have some type of subpoena, which is good. And, you can say, I'm sorry, we're, busy, business is, crazy today. Can I schedule a time for you to come back? 9 times out of 10, that's not an issue. They will do that, and it gives you time to kind of go through and do some, quick walkthrough on your own. Then they'll come through and they'll look at things like that. They'll look for hanging wires. They'll look for tiles that are, open ceilings in the establishment. They'll look for any holes and just obvious things. And like I said, each of those can be a penalty that's associated to that. So, and again, all of that is enforcing positive and safe work environments. Okay. So those are some of the top federal laws that we're going to start off with. There's some other ones we're going to go through, but it's important again to understand the federal laws and how they have the foundation of our state laws and of business. So this is the part that we will stop and ask for any questions from the first part of the presentation. If you have any questions, if you want to go ahead and enter those now in the Q&A portion of the site, and then Tricia can help facilitate those and I can answer those. If not, we will go on to the next section. Okay, not seeing any questions come up at this time. We will go ahead and move on to the next portion. So part of the Department of Labor, they also enforce other federal laws, including leave of absence laws. One of the major leave of absence laws that we all are fairly familiar with or heard, whether we're as an employee or maybe if you've owned any other businesses, is Family Medical Leave Act, or FMLA. Along with wage and hour, I think second to that, the leave of absence laws are some of the most important laws in a work environment that companies want to be familiar with. Coming along in our series that Tricia had referred to, we have a whole training that goes over leave of absences. Today we'll just kind of highlight the top ones you want to be familiar with, but there's so many leave of absence laws between federal and state specific that it warranted a whole separate training. So, but just a little bit background on the FMLA. FMLA was signed into law in 1993 by President Clinton. It was the first major law he signed in. And the problem that it became and why FMLA was brought about is because it was kept coming up that employees had to, be displaced out of employment, were losing their jobs because of medical conditions they could not control. And not only with their own medical situations, whether it be pregnancy, a car accident, cancer, things that come up just as part of life, and then having the double whammy of having to deal with yourself or a dependent or a spouse having it and losing your job at the same time is something that the government on a larger scale wanted to address. And so the FMLA came about. FMLA entitles eligible employees of covered employers, and we'll go through what that means in a few moments, to unpaid job protected leave for family specific reasons. So what this means is even though an employer may have to allot for the time off, it does not mean that it is paid time. There may be paid time allotted through a sick accrual or PTO or something like that, or another policy. But it really says, employee, hey, you had this situation come up. You under the law are allowed to take this time off to take care of whatever you need to take care of or heal, and know that you have a job to come back to, which is one of the most important things. It also addresses the continuation of group insurance, because, imagine that, how horrible that would be to be dealing with a cancer or, going through surgeries for something and, not only lose your job, but, when you have that, you could lose your group health insurance. So that would just be kind of a double hit and really kind of bankrupt someone and put them out of their home and have a lot of dire consequences. So that's another way that this law is helpful. So what does it mean if FMLA applies? That means that someone can use this for the birth of a child or to care for a newborn within 1 year of birth. This could be the placement of an employee of child for adoption or foster care. So it's not just for the birth of a child, but another type of birth, right, with newly placing someone in the home. So it could also be for the spouse or child or parent who has a serious health condition. So not just the own employee's serious health condition. And these are things that make it unable to someone to do the essential functions of their job. And then also there's a portion of it that covers the military that we'll review this morning as well. Okay. So when we take a look at the military portion, in 1993, when FMLA was first put in place, like I said, it was mostly to care for employees and their own health conditions, birth, adoption, and related things, and also their spouse or dependents. You know, when we had 9/11 that happened shortly after, as we all know, we had a lot of our armed forces that were going overseas, going to war and in the Middle East and fighting for a while. And they were finding that members of our military were coming back. They were coming back injured. And not only coming back injured, but they're coming back to families and things that have to care for them. So imagine that you have a service member in your household, your spouse, your son, daughter, or something like that, coming back, they've been injured, and you only potentially have 12 short weeks to kind of address that, give them the services and things that they need to be okay. And they just found that that just was not enough time. So what they did in 2008 and amended in 2010, Congress under Obama addressed this formally and added to Family Medical Leave Act by having its own military carve out that says not just 12 weeks, but 26 work weeks of leave for a single service member to address this. So this was something that was good to address the issue of our military coming back and making sure that they have that support with the government and at home and getting the care that they need. So when we talk about, so who does FMLA apply to? Because it's not applied to every work environment. We're going to talk about covered employers. A covered employer is a private sector employer with 50 or more employees and a 20 or more hour work week, and 20 or more work weeks preceding in the calendar year, or joint employer. So what this means is that it doesn't necessarily mean that you have 50 full-time employees. This can be a combination of full and part-time. So where some companies may run into this is that they're seasonal. They often have a hard time. So, you know, in places, or let's say ski resorts, amusement parks, sometimes they have spikes. Those sometimes they're not always happy with, depending on how long their season is. But it could also be helpful for some people that are seasonal with that caveat of 20 or more work weeks. If your season is a couple months and you may have hundreds of employees during that time, you don't fall under this just because you hit that amount of employees. Another thing to highlight, we have companies that will often open up multiple businesses. And I've seen it before where a company will have, you know, one business and they'll do, you know, 45 employees because they want to stay just under the cusp of the 50, right? And then the spouse will open up another company and call it, you know, ABC Limited. That's a spinoff of another one. And they'll say, you know, we're going to have another 25. And then you'll have, you know, sometimes a child or another family member open up. The law is onto that. So when they talk about joint employer, Fed IDs may be, you know, different and things like that, but some of the things that cause for joint employment, just because it's different Fed IDs, because it has that family relationship, can still be joint employers and still require that all of those companies, because they are connected in a way, are covered under that. Okay, and then also public agencies, local, state, and government agencies, and that's separated out in a lot of laws because there are some laws that we have that are only the private sector and not public sector, like government offices. And then we also have public or private elementary and school establishments as well. That falls under that, and those are considered covered employers in regards to the employee counts. Okay, so then we also have covered employees, because employees may work for a company that is considered a covered employer, but they may not be a covered employee, or vice versa. So to fully qualify for FMLA, someone has to not only be an employee that's covered, but also be and work for an employer that falls under this. So an employee that's covered works for a covered employer. They have worked for that employer at least 12 months. A few years ago, the law was further explained in regards to saying 12 months. We always used to think, and the way it first rolled out was the previous 12 months. It does not have to be the previous 12 months. As long as it's 12 months within a 7-year period, So again, if you have someone that's seasonal or only works there during the off time of school or something like that, if within those 7 years they have 12 months, that portion could have them be covered. But it's not just that. So we're checking off the list, right? So we check the list in regards to work for the employer, but now we're going to add on to that. They have to have worked at least 1,250 hours of service for that employer during that 12-month, the previous 12-month before the leave. So if I'm an employee and that, let's say we used to work for a company and I've left and come back, let's say I left a couple of years ago, I came back, let's say the middle of the previous year. And let's say I have that 12 months, but let's say I came back in, November of the previous year. Chances are in the preceding 12-month period, I probably didn't work the 1,250 hours. So I may have the months in, but I may not have the hours in. And then last but not least, I have to work at a location where the employer has 50 employees within a 75-mile radius. So there are companies that have multiple locations, multiple sites and in different states. And even, and so when they take a look at that, if those 50 employees aren't within a 75-mile radius, so not meaning that they have to all be on site, then it doesn't qualify as well. And I've seen that happen. I used to have a client that did storage facilities, kind of like a public storage, but family owned. And they would have property management sites that would have 2, 3, or 4 employees at each site. But because those sites were so spread out, even though they had hundreds of employees across the US, because they weren't within a 75-mile radius, they did not fall under this law. So it's kind of interesting sometimes how that can happen. I've also seen companies that have a couple locations in different states, but because those state boundaries of where the sites are within 75 miles, then it they fall into place. So those are a few different things that they're taking a look at when they are looking at whether a company falls under this. Okay, so that's the portion in regards to FMLA. Next, we'll go through a couple of other things that are tied to it. So when we look at this, the Wage and Hour Division of the Department of Labor, because we're still under the umbrella of the Department of Labor, this is how big that department is, and the laws, the major laws that it enforces. We get to the benefits and employee benefit security. One of the first things that you may hear a lot of, you'll hear ERISA this, ERISA that. As you put in, let's say if you decide to do a retirement plan, a group health plan, they may say, oh, we want to make sure it's a plan that's ERISA compliant, ERISA compliant. When we look at that, when they talk about ERISA compliant, they're making sure that the plan is set up for the sole and benefits of the workplace and the employees within it, and that it's applied fairly. That's a long story short. There's different testings and things at the IRS because there's some tax portions of these plans that go with that. So not only does it fall under a couple different things in regards to the Department of Labor, there's portions that may be also enforced by the IRS as well in regards to the taxable portions of it. But they want to make sure that these are applied fairly and consistent across the board. So long story short, all the pages and things of ERISA is what it does. Next will happen, you probably have heard about this. You will not hear it in its full name, the Comprehensive Omnibus Budget Reconciliation Act of 1985. We just call it COBRA, which is a lot easier, right? COBRA applies for employers that have group employment that employs 20 or more employees with a group health plan. So what this does is allows employees to continue the plan if they have a qualifying event. So this means not necessarily for the company that that they have to continue to say pay their portion if someone falls below the minimum hours required to get the plan or they leave the company. What it really says that you have to notify the employee that that they're working for a company that has group insurance. What happens if they decide to leave or if they lose that group insurance, and then next offering it to them. And then at that point, a lot of times you'll have a COBRA administrator or someone else that'll deal with it. And it doesn't mean that you still have to pay your employee your portion. Again, it's just more notifications and allowing them the option to continue the coverage. And last but not least, you'll hear Hipaa. Hipaa has many portions to it. One of the main portions is regards to protections of workers, their medical privacy portions, and information regarding their private records. Also, the ability to be able to have portability and health insurance coverage and continuing it. And really, that just goes from company to company. And then also issues with having pre-existing is a portion that could be covered under Hipaa. So those are a couple of the other major laws in regards to employee benefits that are also fall under the Department of Labor in regards to employee benefit security. The next area under the DOL that we'll cover is Ucera. That's the Uniform Services Employment and Reemployment Rights Act. So there's a couple laws that tie into our military in regards to the military protections if they come back injured. But we also have the military leave law that attaches to that. And this protects our service members from reemployment. You know, believe it or not, there are some companies that, you know, when our service members are called to duty, whether it be for training or to go overseas for, you know, for deployment or things like that, that say, hey, sorry about that, but we got to replace you. And they term their employment because they figure, oh, you're employed in the military, we don't have to worry about you anymore, which is not correct. And so federally, we put in Ucera. And this protects our service members and allows for them to have reemployment rights when they are, you know, and doing any type of service duties that relate to their military service or volunteerism. And it says that no employers can discriminate against them based off their military service or their required obligation. Now, this does not say necessarily that they have to pay them for that time. All this is, again, is we're talking about return rights and having that leave of absence that protects them. Okay, Ucera covers nearly all employers, including part-time and probationary. So if you have an employee that comes to you, it's their third day of employment, and they say, oh, hey, by the way, I'm a member of the National Guard, I have to leave next week, here are my orders, I have my training that happens, let's say, quarterly for 2 weeks, and the company would have to allow for that. Okay. And also, Ucera applies to all employers of U.S. regardless of size. One of the things I'll highlight when we say regardless of size, again, there's laws that are attached to, like Fmla, if you have 50 employees and this certain amount of employees. And then there's laws that's regardless of your size that you'll qualify for, that you have to apply for. So that you'll fall under and have to apply to your work environment. And then also Ucera established a 5-year cumulative total of military service with a single employer. So what this pretty much means is if you have an employee that, you know, sometimes, you know, I've had companies where they've had employees that have been, you know, deployed and gone for years at a time. This says that even though, you know, that it's been over a year, 2 years, 3 years, up to 5 years, that they can be out in their military duties, and that you have to keep them on your books per se. So again, this doesn't mean that you have to pay for them and things like that, but this is really, again, just saying, hey, they're still employed, they're still showing as an employee, their employment still counts for vacation accruals and things like that. It's just saying that you cannot terminate their employment based off of them being gone for military reasons. Okay. So this is the last department for the wage and hour division of the DOL that we'll cover. We're going to move on to another department. We have the Office of Federal Compliance, Contract Compliance Programs, the Ofccp. And this department covers anyone that does business with the federal government and receives funds. When I say anyone, it could be one person, it could be a company that has a corporate, you know, corporation with many employees. So it says if you have a contract with the federal government and even a subcontract, then there's some additional laws you may fall under. The size of the contract will determine what of those laws that you fall under. So the size of the contract, number of employees will require whether you have to have, let's say, an affirmative action plan or have certain limitations or extra guidance regarding, you know, training and what types of employees that you have to hire under that will all be determined under the executive orders that enforce the laws that Ofccp has. Okay, when we talk about DOL enforcement on a large scale, the DOL has a sub-department of the Office of Inspector General, and they're the department that conducts audits to review effectiveness, efficiency, integrity of all DOL programs and operations. and award of grantees and contractors and everything, a one-stop shop for everything. And so what they're doing is making sure that companies, through their own audit systems and economic resources, that companies are following all the laws of the Department of Labor. So there may be a wage and hour division that may do wage and hour enforcement, and there may be the OIG that may do other enforcements, and sometimes you'll have multiple departments when you have a violation that'll be involved in enforcement. Okay, if they find that there's an issue, they'll have criminal, civil, and administrative investigations and penalties tied to that. Some of the other things that they're doing and their departments, that they're making sure that there's no labor racketeering, no organized crime. So when we hear, the old school, money launderings, things like that go through employment, they're going to also be a part of those. They're going to also oversee labor, union management and things in regards to benefit plans and things like that. So they're kind of the ones that cover all of the DOL. So in the fourth quarter of last year, and this is just the fourth quarter, they had 149 indictments. They had 125 convictions. They had 84 new cases that they decided to open. They closed 141 cases. But just in one quarter, with the indictment and convictions, they were able to have $65 million in monetary accomplishment. So this is a department that we don't want knocking at anyone's doors, because when they come in, they're obviously said that there's an issue and they're going to be going for some major amount. So that's, when I saw that amount, that's pretty amazing to me there. All right, so it took us almost an hour just to cover the DOL, but we have done it. So we have fully covered the Department of Labor. This will be another part where I'll stop and I'll ask you guys to see if there's anyone that has any questions about any of the things that we've covered in this first portion so far, before we go into our next federal department.
While we're waiting for questions, I just want to say, if you guys attended our compliance session, there's some of this that you'll see that was overlap, because, for example, especially for those of you, well, actually it's everybody, but especially those of you who are growing and infusing, the OSHA stuff definitely comes into play, because you start talking about handling fertilizers and other types of materials that could be considered hazardous, and making sure that you're compliant with OSHA, and all of the different things that the Department of Agriculture asks for. But you as a business owner has to also make sure that your company overall is adhering to HR law. So just more stuff. Basically, most of this is in addition to the stuff that we covered already in that compliance session, because the only piece that I think overlaps for both HR and you in terms of the safety piece is the OSHA. Oh, I see a question. Okay. So the question is, how does a company implement employment laws such as OSHA and Fsla, or FLSA? Does it require the company to write about these acts in their operating plans and employee training plan? Very good question.
Yes, excellent question. Thank you for that. So yes, absolutely. So we'll talk a little bit more about some specific ways that you can do that, but absolutely. So the way to comply are two things: is to have a company policy and procedure that addresses how a company that is affected by an qualifies for these laws and things, how it's going to be handled by the company, acknowledging and informing employees what it is, and how a company complies with it. So that's pretty much the best way of, already saying, addressing it. And then when it happens, and let's say you have an employee that qualifies for a military leave or FMLA, or that you have to, let's say, in wage and hours that pay overtime to, that is then in compliance of these laws. So you have the part one of it, of having the policy in place and notifying employees of the policies and procedures. And the second, making sure that you're compliant by actually following it. So those are the ways that a company can address that. Great question.
I'm typing so that it's captured.
Okay. Perfect.
And then
okay.
You said we'll be covering it later in today's session or in future session?
Today and future, both.
Okay.
Mm-hmm.
Okay.
Okay. All right. We are going to our next department, We have the Equal Employment Opportunity Commission. We also, again, we have our acronyms, right? We have the EEOC, and they will cover our next federal department. So who is the EEOC? The EEOC is responsible for enforcing federal laws that deal with any type of discrimination, harassment. They establish our federal, what's called protected classes. We'll learn a little bit more about protected classes, but really just says that you cannot discriminate based off of any of the protected things: race, color, religion, sex, including pregnancy. Recently, they added gender identity and sexual orientation. They have national origin, age over 40, disability or genetic information. And it's interesting, I want to just highlight that they put the job applicant. A lot of times we think that these are laws related to employment, meaning employees. Many of the laws that we'll discuss also cover job applicants and people before they even become officially hired by someone, or if they don't become hired, there's still protections. The EEOC covers if an employer has at least 15 or more employees. They're covered by EEOC laws. When it comes from discrimination and age-based cases, that's, you have to have 20 employees for that. And, you know, again, it's another area I want to highlight when it talks about employment counts. This is one of the things. So it's, as you grow, it's important to, you know kind of where you are in your laws. Best practice is just to follow this. It's not saying that, oh, you only have 3-4 employees, you can discriminate and harass, and that's okay, because it doesn't hit the federal statute. But I will warn you, there's also state statutes that we will go over as we move ahead. But again, if you're practicing having a positive, safe work environment that's free of harassment and things like this, you don't have to be concerned with the number counts, because it's part of your normal practice. So we talk about who's covered. Private employers, labor unions, and employment agencies are also covered. And again, these laws apply to all type of work situations: hiring, firing, promotions, harassment training, how we apply our wages and who gets paid what, and how benefits are applied. Okay. The laws enforced by the EEOC, they have several major laws, not as many as Department of Labor, the 27 departments and all that, but they have the major. We're going to highlight and focus on 2 today, but I want to briefly touch upon some of the other ones. But one of the major ones that we'll spend some time on is Title VII of the Civil Rights Act. And I have 1964 and 1991. 1964 is when it was signed into law. 1991, there were some adjustments made. Under that, Pregnancy Discrimination Act falls under that. We'll talk a little bit about the Equal Pay Act of 1963. We will go through Age Discrimination Employment Act. We have Title I of the American Disabilities Act. We have the Rehabilitation Act of 1973, and we have the Genetic Information of Non-Discrimination Act of 2008. We just refer to that as GINA. It's a lot easier. A lot of times you'll hear Title VII and ADA and things like that. Those are all fall under the EEOC, and we'll talk more about where those fall into place. Before we touch upon those, I want to briefly talk about the other acts, that way you're familiar with those. The Equal Pay Act, or EPA, really just says you have to pay everyone the same. You cannot have a differentiation of pay between men and women in the workplace in regards to equal work, okay? So if you have 2 people that are doing the same type of job, the same type of work, similar requirements, just because, you want to be careful with that, because just because, let's say, the male negotiates a higher rate or has that, you can't pay the female significantly less. And there's audits to catch that. And we want to be careful, because I talk about negotiations, because a lot of times, recent day, right, when this was put into law back in the 60s, it was a different situation in regards to women's rights and work environment. Today, it's kind of more commonly found accidentally, to where men are typically, and these are studies that have shown this, not being sexist by any means, but a lot of times they're a little bit better at negotiating their salary. So they may say, for, an office management role, for example, they may come in and negotiate, let's say, a $50,000 salary, and they come in and they say, yes, I should be paid this because of this, that, and the other. And let's say the starting pay for the position is $40,000, whereas a woman may come in, get offered the position, and the company will say, the starting salary is $40,000, but we're going to pay you $42,000, and the woman will say, hey, that's great, I accept it, what have you. Well, that's a problem, because now we have an $8,000 gap between what the man has negotiated and what the woman has accepted. and for the same types of work. So we want to be careful with that. And if that was looked at on the outside, when we're looking at payroll records for audits, it's not saying in there, in tiny print with the payroll saying, oh, man negotiated more, that's why he's paid higher. No, it's going to show, hey, this man and woman, gosh, they were hired about the same time, office manager, different locations maybe, but their experience looks the same. So why is he paid more than the other? So that's a lot of times the way that it happens, maybe naturally. Again, not a company purposely trying to do it, but just sometimes the way it may happen. So it's up to the company to try to keep things consistent, and knowing that if they're hiring men or women in at a certain rate for a position, that they're consistent with that, and that the only differentiators are based off of, let's say, time, experience, maybe degrees, stuff like that, that separates it. So if we do have to explain, we're saying, okay, this person is paid more, but this person also comes in with 10 years more experience than the female, or they had a degree, the female didn't have a degree. So those would be the ways that you could separate. And then also it makes it illegal to retaliate against anyone because they complained about or had a charge of discrimination or something like that, or they filed a lawsuit. The next one that we'll go over is the Age Discrimination of Employment Act. This law protects individuals of 40 or older of discrimination because of age. And we've seen this sometimes a lot. Where this will primarily come into place is hiring. I've seen innocently, right? Companies, they'll post an ad and they'll say, we're looking for a young, energetic employee to, work in here. We're looking for people with great energy and blah, 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 blah. And it's like, they put in that little caveat of young. So what does that mean? Someone 40 or older can't be energetic, can't be this and that. So, again, the company's just being careful. Simple and easy as that, as a job ad or something, can be in violation of that. Another time this can come into play is if we have to do a reduction of force or layoff, or, maybe you have to cut back on hours or pay in a work environment. Sometimes a company might say, well, we're going to have to lay off our, employees in management or who've been here a long time. Well, inadvertently, those typically be your, or they'll say your higher wage earners. Those will typically be your employees that have are over 40 because they've been there a while. They've earned these higher wages, and employees who are making less are going to be newer to the workplace and probably fall under that. So inadvertently, it could have what they call a disparate impact, where it, in a negative way, affects these groups of employees to cause a violation of this law. So, and then if someone points it out, of course, retaliation is always covered. If anyone files a lawsuit or something like that, that's covered as well. And I always say that because I've worked for companies where, someone will still be working for them and sue them. And they'll say, well, I don't want this person working for me. I can't trust them. They're suing me. They can't legally terminate them or let them go, because that would be a form of retaliation. So I just want to kind of state that caveat there. The next one is sections 501 and 505 of the Rehabilitation Act. I won't spend too much time on that. Those are regarding discrimination of disabilities of people that work for federal agencies, of not discriminating against them. And then we also have GINA that I spoke about, and this is a somewhat newer law in regards to the EEOC and regarding discrimination against employees or applicants because of their genetic information. And when this law came out, I'll be honest with you, as an HR professional, a lot of us looked at each other and said, what does this mean? Well, as the law was further explained, because that happens a lot where they'll put out a law and then they'll further define it. It really kind of attributed to making sure that there weren't any type of discrimination based off of someone's genetic make. And it's hard to say, well, how am I supposed to know what someone's genetics are when I'm interviewing them and hire them? And, and it could be as simple as someone working for you and they're saying that, oh my goodness, my mother or my, sibling has breast cancer and it runs in the family, and, my aunt had it and this and that. Well, that's a genetic. And then as an employer, if an employer then is like, oh my goodness, I hope they don't get it, or, I'm not going to offer them health insurance because if they get it, my health insurance premiums are going to go up. Or if they by chance, say terminate them because of it, then that would be in violation of this. Again, and that parameter doesn't happen often, but that would be a way that where GINA would come in. The more common thing that we saw where GINA really took effect is really in regards to health plans and how they were done, and even different health programs that were put into place to help kind of reduce a company's health benefits premiums by putting in these type of plans that said, hey, employee, if you go through this health screening with the company and have a health and participate in this, then you can reduce your health premium. And you go through and you used to answer questions. Are you a smoker? Have you had any of these previous things, or anyone in your family have it? And by going through these programs, that information was fed through the health insurance companies. Because it was the type of information that they collected and attached to their genetic potentially predisposition, that was a form of way that discrimination could have occurred. So again, doesn't happen often. It's not the most common, but that's one of the ways. So employers had to kind of work with insurance companies, be careful that any information that they were collecting was not related to someone's genetic history or their family's genetic history. So in talking about those, we will go on to some of the ones that you will be hearing about, and hopefully not dealing with in your work environments. The Title VII of the Civil Rights Act. During 1960s, when this came out, we had a lot of, as we know, civil unrest throughout the United States, and JFK and his dealing with that started putting different civil rights laws into place. And one of them, they affected the work environment. You can't say that you can't discriminate and have separate entrances and seating arrangements and bathrooms and stuff externally and not have that crossover into the work environment. So Title VII is the title of the Civil Rights Act that addresses the workforce. If you've worked at any schools, colleges and stuff, it may be under Title IX and the different titles, but the Civil Rights Act has to do with discrimination. So this is defines and enforces federal laws in regards to harassment, discrimination, and disability discrimination. It makes it illegal to discriminate based off of race, color, religion, national origin, or sex, meaning gender. It also makes it illegal for discrimination or retaliation, and anyone that files a claim or participates as a witness in an investigation. So they're all protected as well. It also defines laws in regards to reasonable accommodation, and also laws regarding harassment and disability. It also furthermore establishes protected classes and adds to them under, again, the 40 and disability and genetic. And you'll see protected classes come up often. These are the federal. There's also states that have added additional protected classes. Okay, what is harassment? Harassment is a type of employment discrimination because it's going to be based off of these protected classes. So, and I use these silly examples, but I will warn you that these examples have come up in the work environment. So, I've had employees come to me and complain, about people being mean to them in the work environment. Oh, so I come to work, they don't speak to me, they're rude. My whole department, everyone that go to lunch, they don't invite me. And, I feel like this is a form of harassment. Well, harassment in the outside world in regards to criminal harassment is a lot different than workplace harassment. Workplace harassment has to be based on a protected class. I had another situation where, and this happens a lot at work environments, right, where you'll have employees that will eat someone else's lunch. So I had someone complain that an employee kept eating her lunch and ate, and was an office offender, would eat other people's foods and stuff that, in the refrigerator. And they're like, this is harassment. This person can't do that. And, whereas it may be rude and, it may violate other workplace policies, right, about respecting your coworkers in the workplace and things like that. Under the definition of harassment, it did not follow. Now, if the person was eating the sandwiches based off of they're a male and the female and eating all the females' lunches, that could be a little maybe different, but extreme but different, but it's got to be based off of a protected class. So when we talk about harassment, that's mostly looking at, again, we have the sexual harassment and we have offensive or hostile work environment, again, based off of these. So when we talk about harassment in regards to sexual harassment, it's unwelcome conduct that's based off of race, religion, color. Again, we have our protected classes. It's an offensive in conduct, and because it becomes a condition of continued employment, which means if it's a one-time thing, accidental probably, to where someone says an inappropriate joke or sends an inappropriate email out or something like that thinking it's funny, does that mean that that's going to turn the place upside down and be the cause for all this litigation? Most likely not. It's going to be something that's ongoing, that's, you know, severe and pervasive, and that really reshapes the work environment for someone or a group of employees where it becomes an issue. And then we take a look at, you know, a reasonable person. Is a reasonable person looking at that going to look at that and say, gosh, oh my gosh, I can't believe that happened to you. That's horrible. That is harassment. That shouldn't be allowed. Then that's also kind of another reason to care, you know, to kind of take a look at that as well. But there are some things that one time and it happens, that's enough. You know, for example, sexual assault in the workplace, violence in the workplace, things like that. Those could be a one-time offer. That's definitely enough to cause for issue. And then we have also other types of offensive conduct. And, you know, when we talk about, you know, threats, intimidation, you know, teasing, insults, put downs, posting things, physical contact, non-physical, how someone is looked at, are also all parts of things that could cross the line. And the harasser can be the victim's supervisor. A lot of times they think, oh, it's the big boss, you know, against the employee. But, you know, just some comfort for you guys is that employees can harass the supervisor as well. It goes the other way. Because harassment is a lot of times attached to power and control over someone, it usually is a someone that's in a position of power, but it can go the other way as well. It doesn't have to be that person's immediate supervisor. It can be the supervisor in another area, someone who's the agent of the employer. So whether it's a supervisor, a contractor that's hired there for them, an owner. It could also be a co-worker, and it does not have to be an employee. It can be a customer that's also the harasser and also is protected. Employees are protected against them under the law. The person does not have to be the direct victim. So let's say you have someone that's constantly being teased or berated at work, offensive jokes or slurs or something like that, that's witnessed by someone else. They too can be offended and therefore kind of become, in a sense, the victim or someone that's part of the harassment. And then unlawful harassment may occur without economic injury. So it doesn't always mean that someone's fired because of it, they're demoted or not hired or something because of it, but it could still have a negative impact to them in their workplace. Okay. So that's harassment, a brief kind of overview about that. Then we'll go over to Americans with Disabilities Act, or ADA. This is the law that protects individuals in the workplace with disabilities and making sure that employers are doing what we can to keep people employed and not use things like their disabilities not to employ them. It requires employers to allow for accommodations to help them stay in the workplace. So when that looks at, we take a look at, it makes it illegal to discriminate against qualified persons with disabilities. So I kind of highlight the qualified because it doesn't mean that just because they work for us and they have this disability and we're looking at accommodations that we have to keep them just because the law says that. If we're looking at, let's say, having to possibly place someone in a different position because of their disability or something like that, it doesn't mean that we have to just do that if they're not qualified, or that we have to create a position for them to apply to properly do this. It also says that the law is a reasonable accommodation. So the reasonable accommodation means that it's not going to be significant difficulty or expense for the employer. So if we have someone that due to their disability could no longer do the majority of their function, it doesn't mean that, oh great, now we have to hire someone to do what they can't do, or, you know, cause someone else to get overtime because they can't do it. Or even more extreme, I always use the major thing of, if you have a company that, let's say, is 2 stories, and you have someone that because of their disability, whether it's something that they came in with that's pre-existing or happens over time, or suddenly their office is on the second floor, it doesn't say, oh, well, to accommodate it, you guys have to put in an elevator because they're wheelchair bound. Well, obviously an elevator would be an extreme expense, and having to do that would be most likely a great financial hardship for a company. It might say that another way to accommodate that is to move their office downstairs. So that could be another type of accommodation. So there's so many different ways that a company can work with this. One of the most common types of accommodation, which a lot of people, it's easy to overlook, is time away from work is a type of accommodation. So if someone's going through treatment, let's say for cancer, giving them time off to do their treatments is a type of accommodation, especially if they're not able to work at the same time. Giving them a reduced schedule, flexible schedules, again, are all types of accommodation and are most common. So, you know, I'll have sometimes companies that say, well, you know, we only have 25 people here, and if, you know, we allow for this person to, you know, be off for a month, you know, that we can't do that. Well, the law looks at it as that, hey, that's not unreasonable. And yeah, it may be uncomfortable and a little bit tricky, but it's not enough of a financial, you know, impact or significant difficulty to not accommodate that. They're going to go through more issues trying to prove later, if there's a lawsuit, financially and all their records and audits showing how they couldn't accommodate it, than to just do it. So just wanted to highlight that. A reasonable environment, a reasonable accommodation could be a change in work environment or how things are usually done. Again, you know, when we look at all different type of accommodations and ailments that someone may have, it may cause, I've had employees that have had issues with sleep apnea and things, so they have to have a little, maybe a later start schedule because of their sleep patterns, and having to get adjusted to different new medications and all types of things. So you may just change their start time. Or something as simple as that. Now, again, if they're an hourly employee, it doesn't mean that, okay, instead of having them work 8 to 5, I work them 9 to 5 and I have to pay for that hour. No, it's just allowing that time. So allowing these flexibilities does not always mean that you have to necessarily pay for them directly either. And then it could also just make it accessible. A simple, I gave the example earlier in regards to a elevator, but a wheelchair ramp may not be out of, you know, the realms and things. I've had clients that have actually had to put in different ramps and things that were a little bit more economically, you know, made sense versus something more major. It could be an interpreter. I've, you know, done phone interviews where I've had to interview someone who was hearing impaired, and we have provided different lines, if they didn't have one already, of someone that was able to do to translate and kind of do an interpreter for that interview. So that could happen. If you have someone that has, you know, visual things that they have, are blind, to have levels of blind, of ways to accommodate that. I've had employees that, a type of accommodation, we've had employees that due to treatments or medical conditions had to bring oxygen tank to the workplace. So we had 2 laws that came into effect with that, right? I had my Osha that I had to check in regards to having that oxygen in the workplace, and, you know, around if we had any hazard chemicals and what that meant. And then just the employee being able to have that with them. A type of accommodation or more frequent trips to the bathroom. There was a case with a grocery chain where there was actual lawsuit where, because of a certain type of medical condition that they had, there was a cashier that the doctor said would need to have more frequent trips to the bathroom. Well, manager A was familiar with this accommodation, and she, you know, she would let them know, hey, I gotta go. They would come, sign her out, she'd go use the bathroom, no problem. Well, unfortunately, one day they had a different manager overseeing that employee, and they proceeded to tell her, no, we can't have you leave your register. We need you to work, and you have to wait and use the bathroom with anyone else. You know, and the employee tried to explain, well, no, it's an accommodation, and, you know, I have this ailment, it's recorded, it's, you know, the company is aware of it. The manager, being not informed of this, still didn't let her go. The employee used the bathroom in themselves. And we talk about, you know, the times that things happen, you know, whether someone has a claim or an issue to bring forth. Again, that was so severe in its first time of happening, with that happening to the employee, that doesn't have to keep happening for that employee to have a disability, you know, discrimination case. It doesn't necessarily matter that every day before, for let's say 6 months, a year, 10 years before they did that, the one time they didn't was an issue. And continue with the ADA, not everyone with a medical condition is protected by the law. So some states also have additional flexibilities with this than others, and are more lenient to what they consider to be a disability. Here in California, for example, if I have an employee that gets severely hit by the flu, for example, even though it's a short-term condition, that falls under ADA and different disability laws locally that we accommodated in certain ways. That doesn't necessarily mean that the flu, because it's a short-term, is protected federally. So just some kind of differences there. Federally, when we look at if someone qualifies for a disability or not, they look at 3 different things. They look at as a person may be disabled if he or she has a physical or mental condition which substantially limits major life activity, walking, talking, seeing, hearing, or learning. A lot of times when we think disability and when we see disability signs, we see the usual, the wheelchair, right? We now know in the day and age that we live in, there's so many types of disability someone has, whether you can see it or not see it. If someone has MS, they're not going to be necessarily in the wheelchair. If you have something that's, again, another type of degenerative disease that happens over time, you may not know it. If someone has seizures, that may happen. They're not going to be in a wheelchair. So those are some physical ailments that have to be, taken into consideration that you may not always see. Mental conditions are also another one, and mental, because we're learning more about mental disorders, it's very real and it happens in the work environment. Another type of mental disorder that can be looked at are also alcoholism and substance abuse. So those are things that could be also considered. Now, that doesn't mean if someone's currently abusing something, you have to accommodate them. It's when they're going through rehab and things with it. A person with a disability doesn't have to be currently disabled. They could have had a history of that. They could have previously had cancer and is in remission. They're covered because there's certain things that are attached to that. And then also the perceived disability of it, physical or mental impairment. And also taking a look at if it's expected to last 6 months, and also a minor as well are protected. So these are the things that we're keeping in mind in the back of our heads as we hear employees talk about things. And I'll tell you, it doesn't happen to where an employee will come to you and say, I have a disability, I need to be accommodated, and this is exactly how it works. Absolutely not. 9 times out of 10, that's not how it happens. It'll come where they'll say, hey, I need some time off, or they may be come in late to work, or they may have outbursts at work sometimes if it's a mental disability. And that's not saying that you come in and say, oh my gosh, you went off on so-and-so coworker, or you're acting erratically, you must have a mental disability and I'm going to accommodate you. No, you're having what's called kind of interactive discussions. Hey, I noticed you've been more agitated at work lately. What's going on? Is there someone we can help? And they can say, you know what, I'm so sorry. I'll tell you, I've been dealing with, this disorder, and my doctor is changing my medication. I'm noticing that this medication is allowing me to be more agitated, or allows me to be sleepy, or different things. So that's how we kind of get into conversations of accommodations and what a company and employers we need to do to assist with that. So, and part of enforcement of the laws is we, have our enforcement. So whenever discrimination is found, the goal of the law is to put the victim back to where he was in the same position, or, nearly the same as if the discrimination had never occurred. So let's say if someone was not hired, because again, this also covers applicants in employment, if someone was not hired because of their potential disability. So that means if they were hired, what they would have made in that position. So, and that can get tricky, right? Because if I don't hire someone because of their disability, I don't know how long if I'd have hired them, they would have worked for me. So of course, they have their calculations that they come up with. But that's taking a look at if someone was fired. They take a look if someone was denied promotion, what that would have meant, or a training that could have maybe meant more money. So those are all the things. A lot of times it's a financial impact, but as we go along and kind of talk through, it could also be mental impact and things like that as well. The types of relief will depend upon the discrimination that happened. So, and I already gave the example of if someone's not selected for a job or promotion, there could be back pay or front pay if they would have gotten it, what they would have received. And of course, immediately stopping those discriminatory practices and making sure that steps and things are put into place to prevent it. And also, if someone is a victim of it, not only are the penalties that are attached to it could happen, but you have attorney's fees. And let me remind you, you'll have your attorney's fees, and then you have their attorney's fees. You may have expert witnesses, court costs, all of those things the employer would have to pay for potentially. So, you know, again, it's always better to practice preventative than to have to deal with something like this later on. Some of the remedies may include compensatory and punitive damages. So we talked about compensatory, those are things directly related to it. Those are, you know, out-of-pocket expenses caused by it. If someone had to have additional medical expenses or go look for another job, excuse me, and it could be emotional harm that they suffered, mental anguish. Punitive damages are really punitive to hurt a company because they are so severe or repeat offender in how their practices were, and that's, or, you know, being malicious or reckless act of discrimination. So not only maybe a company did it, but it was how they did it would be the punitive damages. So for compensatory and punitive damages, federally, again, enforcement, they have these limits of what a company could have to pay for situations where they may be found in violation of this. So, and also just to highlight, this is if a company, if an employee goes through the EEOC, again, there's also state agencies, which Illinois has their own state agency that enforces it. And they can also have a private lawsuit that can go beyond these limits. This is just if the EEOC decides to pursue it, what their limits are and how they base their calculations. The EEOC stats for 2019, there were 72,000 claims that were filed with the EEOC for the different laws that they enforced. They resolved 180 claims for the year. Those 180 cases were $40 million in monetary payments. And so, and you may think, oh my goodness, only 180 out of 72,000 that were filed. Just to kind of take a step back, 72,000 claims may come through. Most of these claims are settled in mediation because that's kind of like the step one of how they go through to resolve something. They'll say, hey, employer, we're formally notifying you that ABC person has filed a claim of discrimination or harassment with us. They're going to set a date to come in and mediate. All they do is provide just a venue for it and to allow for that. Now, let's say $5,000 settlement was offered, the employee accepts, they sign off, things are signed, it stops right there. And most of the time, that's where cases stop. If they move forward, and there's no resolution made, then the EEOC is going to evaluate and they're going to say, okay, is this something that we enforce? What are the merits of it? And then decide again, and they may go back to the employer and say, hey, employer, this is what we're seeing. This case looks like it may have some, you know, some legs to it. Are you sure you don't want to try to resolve this? They'll give them another chance. The company may say, you know, they may have discussions. They're going to talk to their, you know, legal counsel and say, you know what? Yes, we're agreeing to pay these penalties or what have you. You know, the second portion of their, you know, that they have. And then you have those companies that just dig their heels in. We did not do this. We're not guilty. We'd rather fight it. The EEOC may say, okay, well, we feel like this has merit and we are going to pursue it. And when that happens, that's when you see maybe cases that say EEOC versus ABC company. You know, the cases that they actually go forward with are very slim. But you do not want to be one of those cases because when they do, they're coming in hard because now you have those federal fancy attorneys that you're dealing with, not just a whatever attorney that the employee could potentially do. And then you may also have the EEOC may go back to the employee and say, hey, we understand you feel like this has happened. We don't see any grounds for it to pursue it here at the EEOC, but hey, employee, you can get an attorney and sue away or what have you. And, you know, that's another remedy. So along with financial remedies, there's also administrative remedies where I have seen where companies have had to post things that says, hey, we were in violation of this, and they have to post it, sometimes in an employee area and customer area for maybe a year or two, showing that they were in violation of laws. Sometimes there's additional trainings and things that are required. And then they may have what's called department oversight, which is horrible, right? You don't want someone from the EEOC having to be attached to your company to oversee and check your ongoing operations. Or they may say that you have to hire someone internally and pay someone to oversee certain programs. and have a task force or something, because again, that all accounts to the other penalties. So just to kind of give an example, and this is one of the recent lawsuits, and also to point out, a lot of times if a federal agency decides to pursue and go after a company, their resolution now becomes public record. So a lot of times companies not wanting to be attached to that or protect their PR, a lot of times they'll also do settlements where they're having people sign NDAs, and harassment laws have made some changes to that, but still to kind of protect the company's name, so to speak, that way it's not out there. But then you have the companies, again, like I said, that want to take it through, and then they end up on the EEOC's website. And if you ever have some downtime and just want to see how interesting these cases can get, some of them are very entertaining to read through. Again, unfortunately not for the employees involved, but just kind of taking a look and realizing, wow, people are still not getting, the message, and companies are still doing this. But a recent case that settled was an EEOC lawsuit against Whataburger. This is their Tallahassee location, and they had a manager that that they repeatedly instructed to hire only white and not Black applicants. And again, we talked about race as a protected class. And again, this is also addressing hiring. And even though someone's not an employee yet, that they're protected, right? So this is a case that's an example of that. When the manager complained that they were instructed to do this, she was told by upper management that they wanted to reflect the customer base where they do business. And the manager was then subjected to physical and verbal abuse, threats, and schedule changes and things like that. So again, other forms of harassment, and forced them to resign. So once she was forced to resign, they also call that a constructive discharge. Now that person also has a complaint. So these, these are just kind of snippets of the case, but, of course, these are a direct violation of Title VII of the Civil Rights Act. And, of course, after attempting to do pre-litigation settlement through the conciliation process, again, that's that mediation time, right? They couldn't reach a settlement, then they pursued it. So in addition to $180,000 of monetary relief, so that's what the employee was rewarded, there's a 3-year consent decree that requires Whataburger to adopt new HR policies. They have to conduct live and computer-based training, maintain an anonymous hotline for complaints, and they have to post a notice at its worksite about the lawsuit and report any new complaints of retaliation directly to the EEOC. So they got hit on every, end of it. So again, this is on the website. This is a case that actually was just recently posted. So this is kind of hot off the presses. So this is what you definitely don't want to happen. All right, so this ends our portion of the EEOC. Before we go to the Department of Homeland Security, which is the next site, we're going to go through. I'm going to open it up for any questions.
I have a question just out of curiosity, which is the 180 cases, that was cases brought by the EEOC, right?
Correct, that they themselves are going to proceed in court. Correct. So that's not the employee just complaining at that point. That's the EEOC saying, employee, we have picked up your case and we are going to represent you. So, that's when you have the EEOC versus. Typically in a private lawsuit, right, in a civil, you're going to have, let's say if I sue someone, it's going to say Desiree Henderson versus ABC company. Now at that point, they're representing me, so they are going to go after that company because they have seen themselves that there's issue.
And I'll just say, having been involved in a couple of EEOC investigations, one as a person who the company asked to talk to the EEOC on the company's behalf about another employee who had brought a claim, and then another time having actually filed a claim. You do not want to be in that situation. Nobody wants the federal government to come calling, especially not the EEOC.
Right. And that's why I highlight, even though there's a few cases they go after, if they decide to come after you, they're not playing around. So. Yeah.
And it's a long process. It's not something that happens quickly. It's a major disruption. So
it is. And even if an employer by chance has any type of chance of not being found, let's say guilty per se, to Trisha's point, the time and resources and monies that it costs to deal with them is, can get very expensive. And I'll tell you what, on the negotiation side for companies, sometimes we take a look at it. And again, even if we feel like we haven't done anything wrong, when we start taking a look at attorney fees, which easily can be $400 to $500 an hour that they charge to just file a brief or response to them, write their response, file it with them, and provide counsel to you, the clients. And then a lot of times they'll have an initial kind of fee that they'll say 10, 15,000 down, and then after that the hourly. So it can be a good amount of money. So a lot of times, especially sometimes things a little bit frivolous, we'll say $5,000 or $6,000 and settle something, because we know the time and resources it's going to cost and monies to fight something isn't worth it. And it's not saying that the company is guilty, but if there's any gray area with anything at all, it's better just to go ahead and address it. I had a situation at a company where I was a HR, the fast food chain, and we had a management training program. And what we would do is we would get people that have management experience, not necessarily in fast food, but we'd say, hey, if you have this management experience, we can onboard you quickly and be able to get you up to speed, because you have these other kind of competencies that are great, that what we need. And they would do kind of a 3-day kind of trial period where they come in, they're assessed by the restaurant manager and restaurant area supervisors to say, okay, do we think this person can pick it up pretty quick? Well, the second day, the person wasn't quite working out. So they said, this person's not working out. We're going to go ahead and let them go and not have them as a manager trainee anymore. Well, after about a day and a half of working with us, this person decides to sue us. And I'm thinking, are you kidding me? Everybody knows it's a trial program. It's not guaranteed of continued employment. Well, what they failed to let me know is that this person was hearing impaired. This individual, he had the hearing aids that are attached to the head, that's a permanent one in there. And he claimed that that's why he was terminated, and that's why he couldn't understand direction and had difficulties. Granted, he never informed anyone that he did, but this is what he used to bring forward the almost $100,000 lawsuit against us. So we went through mediation. After a full day of mediation, and again, this is a larger fast food chain. So we had our internal counsel that we flew in from the area. We had hired external counsel. So, again, to change the chain. And then this person had their counsel. Then we had to pay for a mediator. So after a full day, we were able to luckily come to an agreement, but it still cost us $30,000. That person worked with us a day and a half, $30,000. I'll never forget that case. That happened, oh gosh, Lillian, that happened about almost 10 years ago now, and that's what it was then. And really, what we were on the hook for, and we'll talk about this a little bit more, and also you'll hear this throughout my trainings, is we didn't have the proper documentation. We didn't properly document that they weren't, why we didn't continue on with their employment. There were some lapses in the hiring practice in regards to, when we notified him that we weren't going to bring him on, we said it was because they didn't have a position available, where the other council could show all these positions available. So it just really made us tighten up in that area, our HR practices and policies and procedures. And that was one of the ways why it was found so important. And because no one did ask him about his disability and offer to kind of go through any type of accommodation with him, that also put us on the hook. So instead of having to proceed and fight that, it was less expensive, or cut our losses there, than to try to pursue it, because it would have involved a lot of litigation and a lot more than what we ended up paying out. So just to add that little fun tidbit to it. All right, so we will go on to the next department. We have the Department of Homeland Security. And you may say, well, wait a minute, why are we dealing with the Department of Homeland Security? We're not, dealing with any, immigration things or anything like that. But the Department of Homeland Security, oh gosh, probably about 7 to 10 years ago now, time flies by so quickly, they became the enforcement over the immigration and let's see, Reform and Control Act of 1986, IRCA. A lot of people, when I say that law, they look at me with a blank face, and I don't blame them, I would too. This is pretty much our requirement to have to use a Form I-9. So this law says that any time that you hire someone within the first really 3 days of employment, you have to confirm and verify that they're eligible to work in the United States. This does not mean that they're U.S. citizens, so there's a difference. It's just eligibility to work in the U.S. So we're confirming the identity of the person and their eligibility authorization. All employers must properly complete the Form I-9 for each individual they hire, whether they hire them for the day, whether it's seasonal work, whether it's part-time. You know, if they're an employee, they're on your payroll, you must have an I-9 filled out for them. And this again includes citizens and non-citizens, and both employees and employers must complete this form. And the Form I-9, any accompanying documentation must be provided or reviewed by the employer within 3 days of someone's employment. And the reason why this was put into place back in the 80s is that, you know, they wanted to make sure that employees were treated fair in the workplace. And what happens a lot of times is that when they were finding when we have unauthorized aliens working in the United States and citizens, employers were taking advantage of them. They were working in horrible, you know, standards, and we saw that when we call it the garment sweatshops or field workers, but even just in, you know, regular, more less physical environments, working in not so good environments, working crazy hours. One of the biggest areas too that often gets hit are restaurants, family-owned restaurants, where they're working all these days a week, all these hours, and not making minimum wage, not making overtime. You know, work conditions. That's one of the things that they're also looking to protect with this law as well. And also fair competition, right? If you're an employer, you're abiding by all the laws, you're paying, you know, required overtime and wages and things like that, and you have another competitor that's not doing that. That's not fair, you know, financial advantage that they have over your company when you're playing by the rules and they're not. It's cheating, it's workplace cheating. So in the way to make sure that everyone is eligible to work in the workplace, they have the Form I-9 that all have to complete. So if you've owned a company before, or been a manager before, or been an employee, you have probably seen some version of this. It's changed over the years, but pretty much this is the section 1, what this looks like. This is the employee portion. So this employee portion, they're filling out their name, their information, the date of birth, the social. One of the things that's changed, they used to say that the social security number was required on it. It is not mandatory anymore. Most times, though, 9 times out of 10, employees will still put it. The employee's email address is put on there. Again, that's not mandatory information, but they can put it on there. Most employees are pretty good about filling this out completely and not asking any questions. I just want to make note of something where you have other last names if used, making sure that for those that really kind of attributes to women, maiden names. So if somewhere in the record they have a maiden name, they'll put that. Otherwise, it's NA there or nothing there or a line drawn through it. And then next talks about, you know, how they're eligible to work in the U.S. Are they a citizen? Are they a non-citizen in the United States? And then it talks about how they could still qualify. Are they a lawful permanent resident? Are they an alien authorized to work and have a work authorization? If so, they have to put that information there. They're signing that everything that they're providing is true, and then the date. Notice the date format. I point out all of these kind of administrative kind of things of how it's filled out, because if these aren't filled out, if they're left blank, if it's, you know, incorrect, if there's an audit, it seems ridiculous, but each of those within itself could be a potential fine. And also making sure it's, you know, filled out, you know, completely and correctly. At the bottom, you'll notice where it talks about a prepared translator. If this is necessary, if someone has to translate to an employee, and I've had that happen before, then they will fill out that portion. If not, that's left blank. No need to worry about that. So that's the first part. That's the employees portion. The second page is the employer portion. This is important also. This is where you, the employer, they bring you the document. Let's say in this example, it's their passport. They're bringing that. You are visibly taking a look at that passport and you're verifying, okay, I've seen the passport. You're writing down the document title, the issuing department, the document number, and the expiration date. Part of that, they cannot bring you anything that's expired. So if I bring you a passport that I had 10 years ago, I let it lapse, that's fine and dandy, but guess what? I cannot use that to help with your eligibility of employment. It has to be an unexpired document. Now, if that expires after I'm working for you, I don't have to go back and recertify anything. That's fine, as long as it was current when I got hired with you. Okay. And then you have list A. So we'll talk about the different lists in a second, but pretty much anything from list A, that's all I need. If an employee gives you something that falls under list B or list C, then you have to have one or the other. We're taking a look at that. Then we're going to write down and make sure we fill in the date of hire for this employee. And then myself, let's say Martha Jefferson, the manager, I am signing that I am the person that saw this US passport. I cannot see a copy of it. I have to see the actual live physical document. And then my title, then I'm putting, I've signed it, I'm printing my name of the company, all the company information. This is a legal document. Okay, so even though you may have printed it offline, whatever it may be, you can also, there's companies that allow ways to do electronic, and you can do it that way as well. But this is a type of legal document. You can be audited for this. You have to be able to show that this is filled out completely, whether it was done electronically or in person with the physical paper. These are the lists. So the I-9 form itself is 3 pages, the actual form, but there's like 15 pages of instruction. And I tell you, this can be so detailed that there's actually a whole employer handbook on the USCIS's website that walks an employer through types of documentation and how to fill it out and all types of things. But pretty much a brief snapshot of this. The list of documents. If someone brings me something from list A, that's all I need. So type of documents that are okay for list A are the passport or passport card, a permanent resident alien card or green card, any of these things. Because a lot of times to get these things, this is going to verify both who I am and my eligibility to work in the US. So that's why this is all that's needed. List B and C, list B establishes identity. So my driver's license, if I give you that, it establishes who I am. So that says I'm Desiree Henderson, date of birth, all that good stuff. Just because I have a driver's license does not necessarily mean I'm eligible to work in the US. You have some places like California that allows illegal immigrants to have a driver's license. So with that, now I also have to have something from list C. That may be a birth certificate. That could be my social security card. So I have to give you both list B and list C, and that those both need to be represented on the I-9 form. And I have to see those physically. So I can't, so if an employee says, oh, I have a copy of my birth certificate, I cannot accept that. I have to see the legal version of the birth certificate, which is not a copy of it. Okay, same thing with the social security card. It's like, oh, and then I'll tell you, every other person misplaces their social security card. And they'll say, oh, I lost, I don't know where it is, but I have a copy of it because my last job took it. I can't, you can say that's great, I can't take that. I need your actual social security card, or you're gonna have to go request a replacement of it, which they can do. Okay. Another part of this is I, the employer, can't say, welcome, new hire, here's your I-9, give me your social security card and driver's license. And the employee says, well, I have my passport. No, I don't want to deal with that. Just give me this. It's illegal for me to determine what documents they give me. Just because they want to give me something I'm not comfortable with, or it's easier for me to just do the passport or something, doesn't matter. I cannot dictate what they give me. I also cannot discriminate against someone because I find out that they're not a U.S. citizen. Sometimes people have kind of, hangups with that. As long as I'm eligible to work, I can't say, oh my gosh, I didn't know you're a Canadian citizen, which happens. I have seen employees have Canadian citizenship, but they're eligible to work here. You cannot discriminate based off of how they have their citizenship or eligibility to work in the U.S. So those are some of the things. A question I often get is, do I have to keep a copy of the documents that they give me? No, you do not. And I'll tell you, kind of best practices, I usually have kept a copy. I'll have an I-9 binder, depending on how many employees we have. I'll have an I-9 binder separated by, last names. I'll have the I-9 document stuff in front, copies of what they gave me behind it. Again, just showing that as a company, I've done my due diligence and making sure that they have provided the correct information, that I saw it. Does that require me to be a I-9 document expert? No, but there are certain things that you can check for. And I will tell you, I've seen some interesting things. I had a client that they were in retail, and they made these handbags, and they had a warehouse of employees, and they had a newer HR person. And, I came in and kind of did an audit. And when she handed me their I-9 book, I cringed. Again, I'm not expected as the HR or even the company to be an I-9 expert. But if in the I-9 book you're looking and you see a permanent resident or green card, and each, and you have 3 different versions of what they look like and even colors in your I-9 book, that's a red flag that somebody's may not be accurate. I mean, I saw where Social Security cards allegedly, you can tell it was typed on, the typing was uneven. I mean, it was a mess. And so those are all things that, why they want you to look at it and practice due diligence. Again, if I get that, I may not be able to say, hey, that's a fake, Social Security thing, but I may say, you know what, I have some additional questions. Can you please bring, something from Social Security department showing that this is a valid Social Security card, because, it looks like there's some, evenness here, this doesn't look right. So, so those are ways that you can further do it, because it's better you do it or your managers do it than they get an audit and they kind of get called out in the ICE audit, which is another department you do not want knocking at your door. Okay, so just some different prohibited practices. Unlawful employment, you do not want to work as a, or continue to work someone who is ineligible to work. Once you find out that someone is not eligible to work in the US, and this can happen accidentally where someone provides false information, that happens a lot. They provide, someone else's information. So it's a valid Social Security card and number, it's just not theirs. I've seen that as well. As soon as a company, you have knowledge of it, you can no longer allow them to work for you. The last portion is failing to comply with I-9 documents. If you fail to comply, properly complete or retain I-9 forms, and if you're audit expected, you can have civil penalties for each violation. And those civil penalties can be quite expensive. So also, if you continue to engage in a pattern or practice of unknowingly or hiring unauthorized aliens, not only can you have civil penalties, but you can actually have fines and 6 months imprisonment. And I'll tell you, it's not always just the owner. Yes, the company owner is, responsible for knowing what's going on in their work environment. But I've seen where managers have a bad practice. I had a manager that, for the same fast food chain. We had some locations in the San Diego area, and they had, so it would be quite common where we would have employees that would live in Mexico and come over across the border to work for us. And as long as they're eligible to work in the US, that's fine. But we had some that were not, and we had a manager that had an environment to where she knew someone was providing false information, and her attitude was kind of like, well, I don't know, I may have known it's false, but it's legit. It may not be theirs, but it's the real social and things like that. I would continue to employ, and if that manager themselves can also receive fines and imprisonment for doing that. So it's not always just the business owners that's on the hook. So managers can also have that as well. If someone engaged in fraud or false statements of misusing visas, immigration permits, identifying documents, again, that goes with those fake documents. And sometimes people will have false Social Security cards are the most common that I've seen, and also permanent resident cards. And there's ways to look up to see, again, on their website, they show pictures and things of what it should look like. Sometimes they change over time. For example, I remember I was auditing some I-9s, and I saw that for some time there was a different department that was doing it, because some of them said, different, like United States, Department of Immigration and things. And then it said Department of Mental Health or something, and Health Enforcement. And I was like, wait a minute, this is, oh my gosh, I found a fake, social. But when I did my research, there was like this random 1 or 2 years where a different department was issuing Social Security cards on behalf of USCIS because of a shortage in their staffing. So when I was able to look up and verify that, so it was just so random. But every now and then you may have something kind of weird like that. But the important part is we did our due diligence. Okay, and the other federal criminal statutes may provide higher penalties in certain fraud cases. So you may have multiple agencies that get involved in something. Okay, so Form I-9 penalties, ICE is a department that enforces these under the Department of Homeland Security. ICE is Immigration Customs Enforcement. That's another department that you definitely don't want at your door, and you want to comply with them when they come to your door. But sometimes it has nothing to do with employment. We had a situation where we had ICE come to the door and they said, we need a list of your employees here. And we said, okay. And, we're like, well, we definitely want to comply. We don't want any issues. But if you can give us more details about what you're looking for, we'd be happy to help you. So finally they said, we're looking for a certain employee. And it had nothing to do with employment issues, because what we had on our end, and again, there's only so much you can do if someone provides you with false information, but this employee was a non-authorized alien that had falsified their work with us, but they had caused a different type of crime. That's what they were more concerned about versus us in employment. Hallelujah, right? So we worked with them and, getting them the employee schedule so that they could, get that employee and coordinating the time that they could apprehend that employee where it wouldn't be a disruption to business. So again, we also, we did everything we could to comply with what they needed, because we did not want them to turn their sights on us any other ways. And it was a situation that was quickly, resolved, non-incident, and it was fine. But again, when that's a scary call to get when you get those agents. They're very serious. They will come in, they'll audit, they'll allow for time to make those corrections. The corrections could be as simple as getting the form I-9 if there's a missing one, making some corrections to the information on current I-9s if there's something wrong, and then no harm, no foul. The additional penalties, and it gets more expensive when someone is knowingly hires and continues to employ violations. Those can range from $573 a violation to over $20,000 per violation, and can go higher than that. When we look again at these violations, we talk about per violation. I just want to kind of let you just kind of, not to scare anyone, but just to kind of reiterate how important this is. Per violation means kind of like each day. So if you have someone that's employed with you and they shouldn't be, each day that they're employed with you can be considered a type of violation. Each incorrectly filled I-9 is a type of violation, even if the person no longer works for you. So that's how expensive and intense this can be. But when ICE is looking at the different factors of penalties, they're looking at the size of the business. So a small mom and pop versus a large corporation. They're looking at, did this company make good faith effort to comply? If it looks like, this is a small family-owned business. They have their auntie so-and-so doing the I-9s and cousin so-and-so does the payroll. They're understanding, hey, this isn't them trying to not comply. This is just a lapse of they didn't know. And they'll come in and they'll do more to kind of work with you, and also taking a look at history of previous violations. So they may let you off with a warning and just say, hey, correct this violation, or they may attach a penalty, but they don't come in immediately with the doom and gloom, so to speak. But if they do, here's an example of a 7-Eleven franchisee that got hit pretty hard. So for 15 years, this manager hired individuals who did not have authorization to work in the U.S. And he not only hired them, but he allowed them to work under false Social Security numbers that he knew to be false, along with other personal identifying information. As a result, what he did is he paid them substandard wages, which meant he did not pay them the minimum wages that were required. So again, less that he has to pay his employees, more profit he can pocket. So this franchisee pled guilty to a conspiracy to conceal and harbor illegal aliens by employing them at his 7-Eleven franchise in New York. And because of that, he faces up to 10 years imprisonment, as well as a fine of twice the value of the gross gain. So this means that any profits and gains that he got from illegally doing this, it's twice that. So it looks like he's going to forfeit more than $1.3 million in his assets, along with other penalties that are going to do this. And this does not include his attorneys and things he had to have, and all other types of legal issues. So that goes with this. So it's definitely not something to, to mess around with. Another major example of enforcement, I don't know if anyone saw this some years ago, but it was one of the largest raids under Obama, our last administration, had to do with Chipotle in Minnesota. In 2011, Chipotle had an audit by ICE. at 50 of their restaurants in Minnesota area. Just started with I-9 audits. This audit opened a can of worms, and within that state and with a few other states like DC and Virginia, found that over 500 employees were illegally employed by the chain in that area. And so out of all those locations, lost 500 employees. Fines were involved in jail time to those local managers because they were knowingly hiring illegal immigrants. E-Verify. So because of this, E-Verify was born, so to speak, right? And this was just another way to help employers verify that someone who's authorized is eligible to work in the United States. E-Verify is a web-based system, and employers can enroll. It is voluntary for most employers. Employers that would be required to do this is if you have a federal government contract. Any other employers that are private can voluntarily participate. And this is in addition to the Form I-9. This doesn't replace it. I had a new client that was coming on, and unfortunately she thought that doing the E-Verify replaced the I-9 component. And I was like, no, we need to get I-9 for your people. I said, it's both. and so we quickly got her caught up. But what it does, it has a system, and you sign up as a company. You post that you are an E-Verify employer, and that you'll be doing an extra layer of verification. And it's an electronic way to check databases to make sure that information that's provided by that employer are correct. It's going to check records of Social Security Administration. It's going to check with Department of Homeland Security to make sure. So if someone comes back or something comes back is not correct, if they give you a false Social Security number or something, 9 times 10 out of that, it'll come back as being incorrect. I will tell you, just from using this system, it's not 100%. There's sometimes that I've accidentally entered wrong information, or I have an employee that accidentally puts a wrong date of birth with a social, and it'll come back as fine. Sometimes there's little gaps in it, but usually it can catch if the majority of someone's not providing accurate information, and it's an extra layer to confirm that someone is eligible. Okay, so that is our information regarding all of our federal departments. So any questions from the first kind of half of our portion of our federal departments you definitely want to be aware of, and any of the laws that we covered? I'll open it now for some Q&A, and we'll kind of take a look at the Q&A box here. Oh, okay, we see one pop in.
Okay, so the question is there a list of forms that employers will be required to complete for employees?
Yes, there are a list of forms. In fact, we have the next seminar that we have in a couple of weeks. I think it's at May 22nd. We actually go through hiring and onboarding practices in that one. So if you're available, definitely join that one. The major list of things, there's very few, I want to say, kind of mandated ones, and several must-haves and best practices. So for example, do you necessarily have to have an employment application for someone? Not necessarily, but you should have one, right? And then if you do have one, there's record keeping and retention things with that. The I-9 and payroll documents, your I-9 and your W-4s, and if your state has a separate tax form, those are really kind of like the ones you absolutely have to have. The other ones are situational, such as like benefit forms, enrollment forms, and the other ones are best practices, and you should have, but don't necessarily have to have. So that's kind of the short answer to that one.
Then we'll be covering the situational and the elective ones and whatnot, those differences in the next one, right?
Yes, correct.
Okay.
Okay, great question. All right, so we've covered federal, and we cover federal because, again, that's our foundation, right? And once we have federal, different states will add on their own compliance. So the state of Illinois, you guys have your departments that enforce different the federal laws, and also have added on to federal laws. So we'll highlight the 3 main ones that you'll most likely be working with. So the Illinois Department of Labor is your local labor department. They're going to enforce the same laws that the DOL is going to enforce, and they may have some different additional requirements, because like I said, anytime a state has their own division with it, they're going to have something that adds additional and promotes different rights with it and additional protection. So again, they protect the rights, wages, welfare, working conditions, safety and health of Illinois workers. The IDOL is responsible for the administration of enforcement of 25 labor and safety laws. And they're divided into 6 departments: the Fair Labor Standards, Conciliation and Mediation, OSHA, Amusement, Ride and Attraction Safety, which is interesting. There's a whole department for that. And the Legal Department Administration. And we're really just going to kind of highlight the ones that you'll most likely, more preventative side, be attached to, and that's the Fair Labor, the FLS portion. And pretty much most of their rules, they're enforcing the Fair Labor Standards Act. So this means that if a company is, if an employer is in violation and an employee wants to file a complaint, they're going to go to the local, the state. Sometimes they don't know, they may still file something with DOL and it'll get kicked down to the state for their enforcement. So some differences, I mentioned earlier about the federal minimum wage is in the, I think it's $7.25. The minimum wage in Illinois is higher, which is fine, again, and that's effective January 1st of this year. Another thing is that overtime is paid once, and hourly non-exempt employee works over 40 hours in a week, and that's the same as federal. Some other things that's different is that recently, and this is important to know, a lot of states are starting to do this to help with inequality in wages. Illinois law does not allow for employees to ask about pay history starting this year. This went into law September of last year. This really is to effect, because sometimes if someone is underpaid based off of their race, religion, gender, something like that, it tends to follow them from employment to employment, right? So if I'm making, let's say, $50,000 a year at employer A, and the market value for this position, let's say $65,000, a year. When I go to another company, they're not going to say, "Oh no, poor employee, you've been underpaid. The market value for this is $65,000." No, I'm going to say, you know what? I'm going to offer you $55,000 or $57,000, and that's an increase for what you're making before, but it's still under the market rate. And that could potentially happen at each employer. So now we're we're level setting, right? We're wiping the slate clean of this potential injustice. So that's why it does not allow for you to ask for pay history, so that current pay is not based off of that. Now, it does not prevent you from asking someone what they're looking to make. That's fine, but it's not asking for the pay history. Provides employees a minimum of 24 hours of rest in each calendar week. That's something that's state specific. Also, another thing that's state specific that the federal law does not require for meal breaks. So in Illinois, a meal period of 20 minutes for every 7.5 hours of work that's scheduled, an employee must have, and that has to be given at no later than 5 hours at the start of their shift. Okay, and there's some states that don't have that. Some states you can work an employee 10 hours without a lunch break, or overtime. So some states have daily overtime, some are weekly overtime. So your state is weekly overtime, but it also has this meal caveat in it. So you want to make sure that you're in compliance with that. And the best way to do that is also documenting that with the timesheet that they're signing in and out for those breaks. Okay, then we have the Illinois Department of Human Rights. That's your state's EEOC. So if someone has a complaint of harassment or discrimination, then they are going to most likely report it to your Illinois Human Rights Department, and they enforce the Illinois Human Rights Act. So this act prohibits discrimination in Illinois with respect to employment, financial credit, public accommodations, real estate transactions on the basis of race, color, religion, sex, national origin, ancestry, and all these. These are their protected classes. I highlight these because, as you can see, there's some of them that are a little different, right? So some of the things that Illinois has is unfavorable military discharge. There's some states that say, if someone was in the military, we want to see that you had favorable discharge. And if you did not, So in other words, if you're fired from the military, then they want to hire you. Illinois said, no, no, you can't discriminate based on that. Whether it's favorable or unfavorable discharge, you cannot discriminate based off of that, which means you can't stop their employment, refuse to hire them employment on the basis of that. So that's something that was kind of interesting and a little bit different than what other states possibly do, as well as federal. Another thing is when we looked at the EEOC, you know, we talked about the counts of employees, right? It covered 15 or more employees and 20 or more for discrimination cases. Illinois, this covers all employees. So if you have a company or 5 or 6 employees, an employee can file a claim of discrimination or harassment based off of these, even though it may not be covered under the federal. Okay, this act, the Illinois Human Rights Act, also prohibits sexual harassment, education discrimination because of citizenship status and things like that. Another thing I want to point out is that, you know, even though Illinois has its own department that handles it, 9 times out of 10, the EEOC will also get involved as oversight. Now, if someone opens a case here, typically there's going to be a case open with the EEOC. It doesn't mean that they're going to necessarily get involved right away, but what they're going to do is they're going to be the oversight. So any resolution that the state has, the EEOC is going to kind of put their stamp of approval on. So if they feel like a state is not, you know, doing enough to resolve it, that they didn't properly resolve it, you know, in Illinois, they may say, you're fine here, or we only feel it's this kind of fine. EEOC may say, no, 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 wait a minute. No, that's not enough. They also had this violation and that, and they could take over. That doesn't happen very often. Typically, the states are better than the federal, but that potential is there. So I just wanted to let you know that. The next thing that Illinois has done that's different from what the federal does is that they have state mandated training. You know, since the inception of Title VII in the 60s, you would think that, well, one would hope, right, that when these laws are put into place, people would follow the laws and companies each year would get better and better. But a couple of years when Me Too came to the forefront and highlighted in many states that, you know, harassment in the workplace is still a major issue and that we need to do more to make sure it doesn't happen. So due to this, many states, including Illinois, have added additional requirements for training that's mandated. So again, beginning this year, all employers, whether you have 1 or 2 employees or 1,000 employees, are required to provide annual sexual harassment training. And for the first round of it, this has to be completed by the end of this year and then annually thereafter. Employers can develop their own sexual harassment training program. As long as it meets all the standards that the state requires, then that's fine. The state has their resources, or they can hire outside firms or someone to help in compliance with this. If you do decide to come up with your own, then you want to make sure that it's in compliance with the state so that it's consistent with what their training things are, that there's examples of conduct that is types of unlawful sexual harassment, that all summary of all the relevant federal and state laws and, you know, statutes and things like that are included. And it also talks about a summary of responsibilities of employers in regards to prevention, investigation, and everything, and that it's presented. Another major portion of this is making sure that this is tracked properly. You don't want to just do the training, but you want to have proof. So if you're audited, you can show, hey, here's my sign-in sheet. You may even have certificates from the training of copies of employees that have done it, just to show proof, along with copies of what you're training on. Okay. So enforcement is very similar to federal enforcement. Enforcement, they have the intake of it, and then again, you have the mediation. Mediation is optional, and the company doesn't have to do it, but I always suggest to go through it because you want to make sure that if you think or you get some kind of knowledge that you may have merit, then you definitely want to make sure you're there to try to resolve it at that initial level so it doesn't go, you know, any further. Okay, so then in the, if nothing's resolved in mediation, an investigation happens, finding of results, and then legal review. Okay, so again, it's always just, I always highlight prevention is best. It's always better to put in programs, policies, trainings to make sure it does not get to this, because once it starts getting to this portion, it takes away from the business. It's, you know, the cost and the time. Even if there is a positive outcome for the business, just the fact of going through it is enough to just not want to have to go through it. Okay. The next department that we will go through is the Illinois Department of Employment Security. This is your department that deals with unemployment and payroll taxes, and we'll focus on the unemployment side of it. It handles some other things, but these are the main things we'll focus on. Unemployment insurance is state operated, so federally under the DOL, they have a high level kind of oversight, but unemployment is state specific. How it operates, what the benefits and pays and payouts are for each state are different. And it's really partially designed to partially replace someone's income. And unemployment gets payable when someone could be temporarily out of a job, so they're furloughed, which is happening a lot right now. If they're permanently out, so if they're laid off, or if they're terminated, or if someone's work falls below full-time because of lack of work or lost wages while being out of work. So I sometimes will have companies ask me, well, we're not laying them off completely, we're just cutting their hours. Well, because it's gonna be a form of lost wages, that person could be potentially eligible for some form of unemployment. So there's people that can be working and getting unemployment. The state allows for up to a maximum of 26 full weeks within a year period of getting it. Another thing I want to highlight is Illinois' job link. So your state has a very nice comprehensive department that assists with job seekers. So this is a site where employees who are receiving unemployment can go on and look for jobs on the job board. And this department can also help you recruit job seekers. And again, it's free to you, which is nice. As an employer, you pay a lot of taxes and, and things to have your business. And so anytime you can take advantage of those, you'll want to. This also allows for different types. So if you work with this group and trying to recruit and get job seekers, there's sometimes tax benefits that you can get with working through them and training programs. They'll help screen job seekers and things for you. So this is great, especially a small business starting up. So they'll help you recruit, they'll set up interview, they'll give you access to training dollars and incentives for hiring and working, and then they'll help you with compliance as well. So I definitely suggest, if you have some time, to kind of take a look at that department and what benefits that they can offer you as an employer. All right, so we have gone through a lot this morning, right? So it's like, okay, now what? We've heard about these departments, we've learned about these laws, it's kind of like a jumbled, of all these things now that's one out. Okay, what do I do? Where do I start? So what do we do now? How does this apply? So how these laws are used, and our additional seminars as we go through the next couple months, will start to attach each of them to different things that could happen in employment. But just a kind of a summary, the laws that can determine how employees are classified. So when we talk about wage and hour divisions and wages with the Fair Labor Standards laws between federal and state, it talks about exempt, non-exempt. We talk about how to pay employees, how much to pay them, how often to pay them, how to hire, and what discrimination laws can be attached to hiring and the process and the I-9 forms. It talks about what documents are required. So we talked about what the I-9 talks about, record keeping and retention. Any forms that you get for an employee, anything that you collect has record keeping requirements on them and how long you have to keep them for. It also goes through what to consider when disciplining and terminating employees. And we have, I think that's either our third or fourth seminar that we go through those. How to properly manage performance. Sometimes disability laws can get into that, and how to manage the workplace benefits, bonuses. Those are attached to the benefit laws like ERISA we talked about, and also other wage and hour laws. So in summary, and having a good understanding, and not to be experts, but just having a good overall understanding, be able to recognize when something may come into place, can reduce your liability, helps you keep your profits, because the last thing you want to do is have to spend your profits defending a claim, and overall helps you stay in business. I've known some great companies that do very well, but unfortunately, if they have too many OSHA claims or deemed unsafe or wage and hour things, it can put a company out of business. Locally, we had one of my last companies I worked for, I was their HR director, and I came in a year after this happened, but they were improperly paying a type of reimbursement to employees who did travel for work. And they're a family-owned business. They had been in business almost 40 years and had about almost 250 employees. And they got hit with a $600,000 was the end-up settlement for this. this could have put them out of business. They were able to split that settlement payment over 3 years of time, but some of the initial, and that was what was negotiated down to, some of the initial cost of what it was going to cost them was going to be more, and they had looked at closing their doors. Luckily, they were able to secure some funds and spread it out and stay in business, but that's something that could have very well put a company out of business. So just because the amount of employees and overtime that it dealt with. So we definitely don't want to have anybody, any of you guys fall to that. And then, overall, it just provides a positive, productive, and safe and work environment. And when you have those situations, you're going to, the success of staying in business and being a great employer just increase incrementally, or substantially, excuse me. So some other legal issues that it helps with employment at will, and we'll talk about these over the next several weeks regarding where that comes in. But employment at will, briefly, is just saying that there's no guaranteed employment. This means at any time, with or without notice, for any reason or non-reason, an employee or employer can end the employment relationship. There's no contracts. It also deals with negligent retention, helps with claims of harassment, discrimination, again, misclassification. It helps with reducing violations of implied covenant and good faith and fair dealing, breaches of contract, collective bargaining agreements, discriminatory treatment, disparate or adverse impact, and violations of public policy. So these laws, a lot of the ones that we went through today, are the foundations as we go through different parts of employment, whether it's hiring for the workplace, managing employees, performance reviews, terminations, compliance with laws, whether with this affects all of these things in reducing a company's liability. So some top things that every company should know. So the top thing that you want to know, and going into business, consolidate your systems. The best way that you can do in having a payroll, your benefits, and the systems that feed into each other, accounting systems. I'll tell you, one of the ways that compliance is missed is when you have so many different hands in the pot versus being able to consolidate and have all your systems either with one company or one agent or broker or something like that, just to really help have a watchdog and an eye stay over that. Have an employment handbook with company policies. I notice, if you guys notice, as I go through all of the laws, there was no requirement to have a company handbook. It is not legally mandated. So, but is that a best practice, something you want to have? Yes. Have an employment handbook that notifies and helps keep track of company policies and things is the way to have, and that helps you keep track of and informs your employees what laws apply to the company and how you guys comply with them. The next thing is train employees in management positions. 9 times out of 10, you, the owner, aren't going to always be directly hands-on with everything. You're going to hire your managers to cover it. And different cases that I've described, who are the violators? Your managers. And because the law looks at them as agent of the business or the organization, you are held responsible for what your managers do. So it's kind of like having minor kids, right? For any of us who have kids, if your kid goes out and spray paints something, they don't sue the kid, they come after you, the parent. So, and then if your kids are a certain age in certain states, sometimes, they'll go after the kid and the parent. So, and this is the same way. So that's why you want to make sure that your managers are getting the proper training as well. That way they don't put you in any bad situations. Classify employees correctly. Make sure if someone's supposed to be an employee that you have them properly classified as an employee and not an independent contractor. So many states are cracking down on this because it violates many laws outside of just employment. There's IRS issues that come into this, workers' comp laws that cross over into this. So you number one want to make sure they're classified correctly. Next thing, another point of classification is going to be their exemption status. You want to make sure that if they're supposed to be hourly and non-exempt and eligible for overtime, that's the case. You do not want to put everyone as salaried, because each day that they're salaried and not potentially getting their meal breaks in your state, getting that overtime that they might get per week, each day that happens for each employee is a violation. You want to be consistent with your policies, and that helps. Again, that's where your handbook policy comes into place. And if your manager, especially if you have multiple managers, they have one tool that they can reference to help with consistency. When you don't have that and you kind of have word of mouth and people using their own interpretation, that's another area where mistakes and errors can happen. Document, document, document. have different forms of documentation so that way you can keep up with employee situations and issues that occur. And just aspects of the employee's employment. You know, like I said, there's only certain things that are legally mandated, but there's a lot of things that are best practices to have that protect you if anything were to come to place. Because if an employee files a claim, I will tell you the employee will have their documentation. You know, they didn't get paid for overtime. They're going to produce all types of records and things that they've been keeping track of each time it happened. And when employees come in, employers, I mean, they come in and they may not have the best record keeping or time and attendance systems, and it will be used against them. So documentation is some of your best defense. Documentation and ways that you show that you're consistent, how you apply your the things that happen, the policies in the workplace. Put systems in place early. Make sure from the time that you start your hiring and interviewing and recruiting and onboarding that you have systems in place of how you bring on employees, how you train them, how you provide them orientation into the workplace. The more kind of I's that are dotted, T's are crossed, and organized you are, the more you can reduce having any issues or being open to any kind of even frivolous lawsuits. And I'll tell you, there's some employees that they make their livelihood off of suing companies, and they know a company that has their stuff together more than a company that doesn't. And you'll have repeat offenders, and they just go from company to company with their lawsuits. And you don't want to fall victim to that. Utilize free government resources. All the agencies that I go through have a training division and employer division where they have employer advocacy groups and people that are hired and work for the DOL and wage and hour division and everywhere, you know, specifically to work and help employers. A lot of times companies get nervous and say, oh no, if I call them and I ask about if this is correct or that, I'm gonna be on their radar, they're gonna come audit me. That's not true. They would much rather you call and check ahead of time than have you not and have an error and have to come in. Last but not least, have fun. I mean, this is an awesome opportunity. It is great to be a business owner. That's the foundation of our U.S. economy and business owners. So congratulations to you guys, and I wish everyone the best and compliance. Any questions? I know we did some questions as we went along, and just wanted to open it up for questions about anything that we went through today.
While we're waiting for questions, I want to just make a couple of comments. On the minimum wage, so for you guys that are in Chicago, and Desiree, you wouldn't know this because you're in California. For you guys in Chicago, the Chicago minimum wage is higher than the state minimum wage. So you want to make sure that you're following any local jurisdictional guidelines. I do not remember, I don't think so, but I might be wrong, so you want to double check. If you're in Cook County or if you're in any of the collar counties, so Will DuPage, Lake, I know I'm forgetting one, but anyway, if you're in any of the collar counties, you want to make sure that your county doesn't have its own minimum wage. I don't think that they do, but there are a lot of changes that happened last year. And also, minimum wage in Illinois is scheduled to go up on July 1st. So by the time you guys actually are hiring employees, or by the time you get your license especially, so if you're in business right now and you're hiring employees, then yes, the minimum wage is $9.25 unless you're in Chicago, which is higher. On July 1st, the minimum wage will be $10. So make sure that you are following, you're keeping up with the minimum wage changes, and that you're accounting for that in your budgeting and whatnot, because it's gonna obviously have an impact.
Mm-hmm. Absolutely, yeah. Oh, I think we have a question.
Yeah. When are employee forms such as I-9 required to be completed? For example, should they be completed a few months before the employee starts work?
They're completed not a few months. So once you make the offer and they're prepared and they're getting ready to work, the best practice is on their first day of employment, have them bring their documents with them. You do not want to get it too soon, because you don't want it to look like you are screening based off someone's eligibility to work. You can ask them, are you eligible to work in the United States? They say yes, and it ends there. But then once they're officially hired and onboarded, that's when you would get the documents then. And you have 3 days, within the first 3 days of work employment, get everything. Like I said, the best thing to do is day one, let the employee know that when you come in for your orientation, here's here's a list of acceptable I-9 documents. Please have that with you first day. And then a couple of days, as if by chance you just have to kind of chase someone down for it. But those are the requirements.
Something else I just want to bring up also, and that's because of the nature of this work and the nature of the license application. Handbooks are actually required because they were in the application. So now, interpretation of what that actually meant, whether that's general policy handbook or daily policies and procedures or daily checklists or whatever, the department kind of had left that open because they didn't really identify what that requirement actually looked like. But a lot of you already, I know, may have already done a handbook. So this information is an opportunity for you to go back and possibly readdress, your handbook before you actually get started, or before you get your license, or maybe right after you get your license. So you're kind of ahead of the game there because many of you already have it because you applied a couple of days ago.
Absolutely. And then, a lot of times people get nervous about, I have to do a handbook, and they picture this big old thick, book or what have you. But really, handbook is just a compilation of policies. And it could be as simple as your most common policies and laws that you follow, typed up or printed out in the thing and slapped together. Now, the more organized and the more cohesive it is, the better for you, because then it's going to be easy for employees and your managers to understand when doing the policies. But it does not have to be anything. It doesn't have to be anything that's scary.
Yep, absolutely. And then one other thing I wanted to bring up just as an aside, as you guys are looking at I can't remember exactly where it was. It's towards the end there, but you were talking about record keeping and pay and whatnot. Make sure that you were talking about independent contractor versus employee. Make sure that you include yourself as an employee and that you pay yourself a competitive wage for your role as an employee, because what you don't want to do is basically avoid the payroll taxes, because eventually the IRS will come after you. My father is a retired IRS auditor. We were just having a conversation about this last week. So I did a lot of research on okay, well, exactly how much should my pay be? So you don't want to overpay in taxes, but you don't want to pay nothing, because that is a red flag.
Mm-hmm. Yes, and and outside of employment realms, misclassifying someone and putting them as independent contractor versus an employee, law firms will tell you that's one of the most expensive mistakes a company can make, because there's so many laws you're not paying. You're not paying in the workers' comp. You're probably not paying unemployment. Your taxes for them, state and federal, and everybody wants their money.
Yep, so. Absolutely. And they will come after you. And the case law that I looked up in the research that I did, and like I said, we just did this last week. There were some cases where I looked up, and there was a guy who was a CPA. So he obviously knew what he was doing. And they were like, yeah, no, you can't do this. You should have been, I think he was paying himself minimum wage or something. And they were like, yeah, no, you need to be paying yourself a minimum of this much. And so then the penalty was huge.
Yeah, because they'll calculate what it should be.
Yep.
They'll calculate, for example, for the, misclassification of employment, they'll calculate, what it should have been, what it is, and then the penalties with it. And I'll have companies that say, well, they want it to be a 1099. They asked to be, because they want to avoid different deductions and hiding from the IRS, or most commonly used for child support. And it doesn't matter. It's, the employer is held accountable, not the employee. They won't go back to the employee for past taxes and things like that. They go after the company. Yep.
We have another question.
Oh, great.
Do you have an example of an employee handbook, and is a handbook where you would discuss the federal and state employee laws?
Yes, I mean, there's different examples out there. I know, Like Tricia has said earlier, I can always have some one-on-one discussions with you guys in regards to if anyone needs help putting together a handbook or needs me to review what they have or something like that. But there are a lot of different examples, or at least how to formulate the policies that you want to put in there that can be provided. And I'm sorry, what was the second part of the question?
Is a handbook where you would discuss the federal and state employee laws?
Exactly. Yes, it would be. And that way you would talk about what laws apply to you. Now, let's say you're a company with 25 employees, you wouldn't put anything about FMLA in there because FMLA is not a leave that would apply to you, only the laws that apply to you and your employees in your workplace. Great.
And I'll say this in response to what you just said, even though I have a hard time talking and typing. So Desiree can be available for one-on-ones. It is not for her to prepare your handbook for you. We have a limited number of hours that we've allotted and that DCEO is reimbursing us for. So I want to make sure she's available to as many people as possible. But if you have an example of a handbook or you have your own handbook already and you want her to look at it, we can definitely facilitate that. And then we can also facilitate, you know, just a direct one-on-one conversation as well. So if you want that, and I'll put it in the chat too, you can send a note, an email to cannabis@thetrepschool.com, and then we can facilitate that. So I'll coordinate with Desiree offline, and then we'll make it happen.
Absolutely. Another thing I just put up here are the websites, the government sites, so you can find all the information that we've reviewed on the federal and states. You can kind of see if you ever want to, you know, if you just want to go back, you're bored, right? You want to go back and look through them. So no one ever, right? Other than myself, I consider myself an HR nerd. The stuff I love going to the updates and the conferences because it's always something new that's coming out the pipeline. And then, you know, I just want to thank you guys for the opportunity to present to you this morning and for your time. I hope that you found it helpful, and feel free to follow me on any of the social media sites here and ask questions. And I, you know, a lot of times I'll post a lot of some fun and interesting facts on there as well.
Well, thank you, Desiree. And again, this recording will be made available. So I will be sending out an email to everyone once it is available. And I'll be sending you guys a survey as well. So, so barring any other questions, go enjoy your, well, it's sunny here in Central Illinois. I'm assuming it's sunny or hoping it's sunny in the rest of the state. So go enjoy your Saturday afternoon, but make sure you stay 6 feet away from anybody else.
That's right. Thank you, everyone. Have a great day.